Good morning, everyone. Morning, Dr. Smith. Can I just raise one matter before the business of the day starts? Yesterday, I had cause to mention an article which had appeared in the press, in Virgin Islands News Online, which revealed the contents of the Minister's position statement on governance, which was a document to which a duty of confidence attached. I mention it now because further queries have been raised by the press as to the current position with regard to the inquiries which I ordered to be made yesterday. I directed that the Attorney General and the Governor's Office respond by 9 a.m. Today with a list of people who had had access to the position statement and the inquiries that had been made as to whether any of them had breached their duty of confidence. The position is that overnight, both the Governor's Office and the Attorney General have responded to that direction. As a result of the Governor's Office response, I have already met the Governor and the 3 members of the Governor's Office who had access to the position statement, and I have satisfied myself that the breach of confidence did not emanate from any of them, nor, as I indicated yesterday, did it emanate from any member of the COI team in the BVI, who number 5. The Attorney General's response is that disclosure within the BVI government and legal team was quite widespread, and her inquiries are ongoing, and she is going to write to me again when those inquiries are complete. Thank you, Mr. Rowett.
Thank you, Commissioner. If I could also, for the purposes of the transcript, record that there are no legal representatives present here on behalf of those who have participant status in the Commission of Inquiry. Our first witness will be Dr. Daniel Orlando Smith. But before Dr. Smith is sworn, may I take this moment just to read some evidence into the record?
Certainly, yes, thank you.
For the transcript, what I'm going to read extracts from is a report of the Registrar of Interests covering the year 2008 to 2009. That report was submitted to the then Governor and the then Deputy Governor in May 2009 by Victorine Romney Varlack, Registrar of Interests. As you will remember, Commissioner, Ms. Romney Varlack only recently retired from the post, having held it since 18th of February 2008. The report covers the year 18th of February 2008, 18th of February 2009. I do not intend to read every single part of it, but only those portions that are relevant to your inquiry.
Yes, thank you.
It begins with an introduction, which is as follows. There is no statutory requirement for the registrar to make a report. However, the registrar compiled a report on the activities and status of the Office of the Registrar for the period 18th of February 2008 to 18th of February 2009. This report is primarily for the information of the Governor and the Deputy Governor. It is not intended to be circulated or tabled in the House of Assembly. The next heading is Register of Interest Act 2006. And the text reads as follows, quote, the Register of Interest Act 2006 was passed by the Legislative Council of the Virgin Islands into law on 2nd May 2006. It was subsequently gazetted on 1st of June 2006, but was not brought into force until 18th February 2008. Section 1 of the Act provided for the Chief Minister within 6 months of enactment to appoint a date by a notice published in the Gazette for the coming into force of the Act. This was not done within the time specified. An amendment to the Act passed by the House of Assembly on 27th December 2007 authorised the Premier to appoint a date by notice published in the Gazette on which the Act was to come into force. The Act was brought into force on 18th February 2008. The next heading is appointment of Registrar, and it reads as follows. The Virgin Islands Constitution Order 2007, under Section 112, makes provision for the appointment of a Registrar, who may also be removed from office by the Governor acting in his or her discretion. Simultaneously with the coming into force of the Register of Interest Act 2006, the Registrar was appointed on 18th February 2008. On 20th of February, the oath of confidentiality, as required under Section 13 of the Register of Interest Act, was sworn by the Registrar before the Registrar of the High Court. The report then gives some details about the office and administrative support given to the Registrar. I won't read that out, but I pick up the next heading, which is as follows. Quote, statutory requirement for members' declarations. And it then continues. Section 3.1 of the Register of Interest Act makes provision for the period during which members are to make declarations. They are 1, within 30 days after the coming into force of the Act, 2, on the date on which a member assumed the functions of his office, and 3, on each subsequent anniversary of that date. When the Act came into force, members had already taken office on September 14, 2007, following the general elections held in August 2007. Members were therefore required to file their declarations twice in 2008, the first being within 30 days after 18th February, and the next being 14th September 2008, the first anniversary after members had assumed office. Because the 14th of September fell on a Sunday, the filing date was Monday, 15th of September 2008. The next heading is headed Meeting with Deputy Premier / Chairman Standing Orders Committee, and it reads as follows. The Registrar on 21st February 2008 wrote to the Deputy Premier, who is the Chairman of the Standing Orders Committee of the House of Assembly, to seek her advice on how to proceed in the absence of the Standing Select Committee, in the hopes that this would have galvanised some immediate action. A meeting on 6 March with the Chairman and the Registrar resulted. The Chairman promised to dialogue with the Premier to convene a meeting to amend the standing orders. Such amendment has not yet been made. The next heading of the report is meeting with members of the House of Assembly, but that isn't relevant and I won't read it out. But the next section is, it is headed Filing of Declarations, March 2008, and reads as follows. Members of the House of Assembly filed their declarations within the time specified. On 19th March, the Registrar's office was very busy receiving both members and their declarations. The next heading is Filing of Declarations, September 2008, and reads as follows. Although members had advance notice and several reminders for the second set of declarations, which were due on 14th September, 1 year after their taking office, the Registrar was acutely disappointed that all members did not file their declarations on time. In fact, some members did not file until several months later, the last being received on 10th February 2009. Had the committee been appointed, Section 7 of the Act would have been invoked. The next heading is Register of Interests, and that reads as follows. The register that is required to be maintained by the Registrar under Section 4 of the Act remains just a blank book. The committee that must approve the format of the register has not been appointed because the standing orders of the House of Assembly, under which the Standing Select Committee falls, have not been amended as of the date of this report. It follows then that those areas for which the committee is responsible have gone without attention. It continues. The Registrar is of the opinion that the amendment to the standing orders of the House is not a priority, even though several reminders have been issued by the Registrar to both the Speaker and the Chairman of the Standing Orders Committee. Note should be taken here that the report of the Standing Orders Committee for amendment was laid on the table of the Legislative Council as far back as 20th of March 2007. The report continues, early in July 2008, a member of the press visited the registrar's office to inspect the register. The member was visibly disappointed when he was informed that the register was not open to public scrutiny. The registrar referred him to the section of the Act which dealt with the confidentiality of the member's declaration. Following this, the registrar issued a news release to update the general public of the functions of the registrar's office and to remind readers that the register is not open to public inspection. On 17th July, the Register of Interest was the subject of an editorial in the BVI Beacon, accompanied by a cartoon headed Commentary House of Assembly, Register of Interest. The cartoon depicted an open cookie jar with a closed to the public sign surrounded by barbed wire. Again, if I move forward to the report to the next relevant heading, it is headed Amendment to the Register of Interest Act. And the text reads as follows. During the speech from the throne in 2008, it was announced that the Register of Interest Act is to be amended to include senior public servants. When this amendment is contemplated, it would be opportune for other amendments to be taken simultaneously. Careful consideration will, of necessity, need to be given to avoid any conflict between whose declarations are to be private and confidential and whose declarations are to be open to the public. Other considerations would be the remit of the registrar, office accommodation, staffing, among others. Dialogue with the Registrar of Interest could prove beneficial while compiling the various amendments. The report's next part of the report concerns the budget of the Office of the Registrar of Interest. And again, I won't read that out, but the Registrar's conclusion is as follows. This report is for the information of His Excellency the Governor and the Deputy Governor. As there is no statutory requirement for reporting, the report is not for publication in any form. Commissioner, the report as submitted to the Governor prompted a response in the form of a memorandum from the then Governor, David Peary. And this was dated the 16th of June, 2009. And if I may, I will read an extract from that.
Could I have the reference, the bundle reference to the report?
The bundle reference to the report that I've read out is the it's the Governor's disclosure bundle, and it is at page 81.
No, thank you very much.
And for the record, the statutory instrument, the notice under which the Registrar Victorine Romney Varlock was appointed is at your page 80.
Thank you.
The memorandum is dated the 16th of June, 2009. You'll find it in the same bundle at page 87. Again, if I read out the response of the then Governor, it is as follows. Thank you so much for preparing the above report and forwarding it with your memo of 8th of June. I congratulate you on a sound start in introducing to the BVI this important constitutional position, which can contribute significantly to open government in the territory. I agree that the 2006 Act has its limitation. It is, in a sense, no more than a beginning to what should become a rigorous and open process. The two areas, in my view, where the Act should be sharpened up are A, in making the register public, and B, in giving the registrar teeth in the event of non-compliance. Such amendments will need to be carefully balanced so that all parties, open brackets, politicians included, close brackets, can see the benefits of greater rigor. You might therefore benefit from furthering your research into similar registers in other countries, so that when you see the Premier, you are able to present to him a set of carefully judged outline amendments. If these are accepted, they might then stand a chance of being quickly transcribed into law. I would welcome your clarification on the matter of the Standing Select Committee. The middle paragraph of page 2 of the report suggests, I believe correctly, that you are pressing as a priority for this Select Committee to be appointed. On the next page, however, you seem to say that this should not be viewed as a priority. My own view is that the first of these positions is correct. The Select Committee needs to be approved so as to bring the provisions of the Act fully into force. And the then Governor concludes this memorandum with these words. Many thanks again for the report. You continue to enjoy my full support. The Registrar of Interest responded to that memorandum, and this is in the same bundle at your page 90, Commissioner, with a memorandum of her own dated the 23rd of June 2009. And it reads as follows. Thank you for your memorandum of 16th of June 2009. I welcome your views and indeed agree that the Act needs sharpening in the areas you have outlined. There are others that I'm identifying for further discussion with the Attorney General to obtain her legal opinion. I want to address the matter you raised in your third paragraph regarding the Standing Select Committee. I believe the paragraph that has given rise to my apparent contradiction is the following. And the Registrar's memorandum then quotes as follows. The Registrar is of the opinion that the amendment to the standing orders of the House of Assembly is not a priority, even though several reminders have been issued by the Registrar to both the Speaker and the Chairman of the Standing Orders Committee. Note should be taken here that the report of the Standing Orders Committee for Amendment was laid on the table of the Legislative Council as far back as 20th of March 2007. And the quoted text in the memorandum ends there. The memorandum then continues with the Registrar recording as follows. I remain firm that the standing orders of the House need to be amended and should have been amended since 2007 to bring them in line with the changes brought about by the 2007 Constitutional Order and to recognise those areas recommended for amendment by the Standing Orders Committee. Perhaps the following text would clarify my thinking. And she then sets out some text, which I will now read, and it is as follows. Quote, it appears that the amendment of the standing orders of the House is not a priority for those concerned with bringing about the amendment and subsequently appointing the Standing Select Committee to work with the Registrar of Interest, end quote. And the Registrar concludes her memorandum as follows. I trust that this explanation gives some clarification on the matter. I do look forward to your continuing support. Thank you. Commissioner, unless you wish me to read more, that is all I wish to put into the record at this moment.
Yes, thank you very much.
But if I could ask if Dr. Smith could be formally sworn.
Yes, thank you.
Good morning. Would you like to swear an oath or make an affirmation?
Affirm.
Affirm? Yeah, that's fine. If you could just read what's written on the piece of paper.
Understand?
You don't have to.
Okay. I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Yes, thank you, Mr. Rowan.
Thank you. Dr. Smith, first, thank you very much for coming to give evidence to the Commission today. There are some formalities that I need to deal with, as I do with every witness. The first one is to ask you, please, to give the Commissioner your full name.
Daniel Orlando Smith.
Were you still a member of the House of Assembly, I would ask for your professional address, but I won't do that now. What I will tell you is that, and this is what I say to every witness, is that I do try and keep my questions short and simple. It doesn't always happen. So if at any time I ask you a question that you have difficulty understanding, then please don't hesitate to ask me to repeat it or to rephrase it in a different way, and I will try and do so.
Okay.
There are, to your left, as you'll see, a number of bundles. You don't have to open any of them at the moment, but I will take you to various documents in those bundles as we go through your evidence. The final thing, and this is something I say to all witnesses, is that the microphone that's in front of you is just there to record what you have to say rather than to amplify your voice. And so it is important, if you can, just to keep your voice up, speak slowly, and that way your answers can clearly and accurately be recorded on the transcript of the hearing. Can I start again? And this is a question that I have put to every witness that has come before the Commission. And it is to ask you just to give a brief outline of your professional background before you came into politics.
After leaving high school, I attended the University of West Indies in Jamaica to study medicine. And having completed the course of study there in 1969, internships in the Bahamas, I then returned home for 1 year and then traveled to the UK to pursue studies in general surgery. And then returned home where I was the surgeon at the hospital. There was only one surgeon in the BVI at that time. Sometime later on, I became the chief medical officer of the territory. But before doing that, I traveled again to the UK, where I did a master's in community health in developing countries and a public health degree, and then returned home to continue with work as general surgeon and as chief medical officer, and for a time as hospital director.
Thank you. And correct me if this is wrong, but is it right that the first time that you were elected as a representative was in 1999 when you were elected to the Legislative Council?
That is correct. Yeah.
And were you at that time the head of the National Democratic Party?
I was the head of the party, yes.
And again, correct me if this is wrong, you obviously were on the Legislative Council and you remained on the Legislative Council between 2003 and 2007, when at that time the NDP, with you at its head, was the largest party on the council.
Could you rephrase that?
Yes. Oh, yes, I will do. So 1999 is the first time you're elected to the council.
Correct.
And between 2003 and 2007, you also served on the council.
Between 2003 and 2007, I served as on council as the chief minister.
Yes, and that was because at that time the NDP was the largest party on the council.
That is correct.
Thank you.
That was after the election in, I can't remember the 1969, I think. Okay, 1969.
2003, I think.
2003.
Sorry, 2003, yes.
So again, Dr. Smith, if we could ask you, you're quite softly spoken, so if you could raise your voice a little.
Okay.
If you feel the need to shout towards me, don't hesitate to do so. When it came to 2007, obviously at that time, there was a constitutional change, a number of constitutional changes, one of which, of course, is that the Legislative Council became the House of Assembly. But is it right that in 2007, you and the NDP became the opposition?
That is correct.
But you returned to government in 2011. And then at that point, you took on the position of Premier and Minister of Finance.
That is correct.
And between 2011 and 2019, the NDP formed the government across two houses of assembly.
That is correct.
And over that period, you remained as Premier and Minister of Finance.
Correct.
Is it right that you retired from politics before the 2019 election?
That is correct.
And so you didn't stand in the most recent election?
I did not. Yeah.
But in terms of the span of your political career from 1999 to I suppose the end of 2018, if you like, were you throughout a territorial candidate, or sometimes it's described, I think, sometimes as an at-large candidate?
Yes, I was a territorial candidate for all the elections.
Thank you. You will have heard that me reading from the report of Ms. Romney-Varlak and from the material we've sent you, it will be clear to you that one of the issues that is being investigated at this stage of the commission is the operation of the register of interests. What is your current view on publication of the register to the public?
I have actually not thought about that recently. When it was enacted, it was private, for the held by the registrar. It is something I have to give some more serious thought before I can make a comment on that. Given the whole situation here in the BVI.
For yourself, you would have been a legislator in 2006 and through to 2008 when the Act was first of all enacted and then brought into force.
That is correct.
Yes. Again, you will have heard from that it was the registrar's view that it should be public. When you were in office at that time, did you have a view about the benefits or the risks of making the register open to public inspection?
When I was in office, there was a collective view that it should not be public of the legislators.
And did you share that collective view?
I shared that view at that time.
And what was the reason, from your perspective, for keeping it private?
The reason for keeping it private is that once it becomes public, then everyone and anyone gets into the business of legislators and people who have been elected to serve the territory. And in BVI, sometimes those interferences into the business of legislators can be very disturbing and can be very serious. And that is why members felt that it was best at that time not to make it public.
And you said it was a collective view. Was it a unanimous view?
I would say yes.
And so it wasn't a party political issue, to your recollection?
No.
I appreciate that you've obviously been out of office now for some time, and you will have had some distance from the Register of Interest Act. So if I can I just, to assist you, just remind you of the obligations that it imposed on members. You should have in front of you, I hope, a bundle which is headed Constitution and Legislation bundle.
Okay.
If you could, Dr. Smith, please turn to page 59 in the bundle. This is the first page of the Act. When it came into force in 2008. And so the obligations it placed on legislators was obligation on members of the House of Assembly. It was amended before it came into effect to change the references that we will see in the Act, which refer to Legislative Council to House of Assembly. If I take you, please, to page 61 and section 3. Section 3.1, and I'm going to summarize it, but what the effect of section 3.1 is that it imposes an obligation on a member to make a declaration using the form that's scheduled to the Act within 30 days after this act comes into force, and thereafter on the date on which he assumes the function of his office and on each subsequent anniversary of that date. And the registrar's report explained how that worked. The declaration that has to be made, and we see that at 3.2, is a declaration in respects of interest held on the date on which the duty to make the declaration arose. So looking at that, Dr. Smith, would you accept that members of the House of Assembly had an obligation on the date that they were sworn into the House to make a declaration of interest?
That is what is indicated in this document.
And so if they didn't do it on that date, they would then be in breach of the Act, wouldn't they?
However, on the day that you were sworn in, there's quite a lot of activities around that point. And I'm sure it would have been easy for that day to slip.
Yes. Well, perhaps I'm going to take you in due course to your own declarations, and it may be that might be a point for you to elaborate on what you've just said. If you could turn to 64 in the bundle, page 64, please. And I'm taking you to section 7. I'm going to redirect your attention, please, Dr. Smith, to 7A. Where a member fails to make a declaration within a period of 3 months from the date on which the duty to make that declaration accrued, the member shall be in breach of the provisions of this Act, and the registrar shall, within 14 days of the knowledge of such brief, submit a report of such brief to the committee, which shall meet to consider the report within 21 days of its submission. So the effect of section 7 is to create a second occasion when a member could be in breach. If within 3 months of the date of which they are, they should have submitted the form, they still haven't, then again, they're found to be in breach. Would you accept that interpretation of section 7?
Yes, it depends also, as I read here, on notices given by the registrar to the particular individual.
Yes, that's a slightly different provision, because the registrar, I think are you looking at B, Dr. Smith?
Yes, B and C.
Yes. I can take you to those, but there is an obligation under section 5.4 and under section 5 for the registrar to check. If you're turning it up, if you go to page 62, what section 5 asks or mandates a registrar to do is first act as the clerk to the committee, second, enter into the register the interest declared in each declaration. But before doing so, the registrar has to satisfy himself or herself that a full and accurate declaration has been prepared. And this is the point where the notice requirement arises, and that's at 4, where the registrar is satisfied that an entry in the register has been made as a result of a fraudulent or materially misleading declaration, then the registrar shall mark the entry as cancelled and by notice require the member to make a new declaration. So that requirement only arises once the registrar has inspected the declaration. And section 6.1, because you've drawn attention to that, and that's at your page 63, Dr. Smith, it gives the registrar power to, by notice, require a person to supply to the registrar information or produce records. So the registrar, in order to satisfy himself or herself as to the accuracy of the register, can require further information from a person, including a member of the House of Assembly. But the point that I was making to you is that what section 7 does is create yet another obligation on a member of the House of Assembly. If they've missed the date, the due date, the date that section prescribes, they have 3 months to get the declaration in. And if they haven't done it within 3 months, then a report has to be sent by the registrar to the Standing Select Committee. So would you accept that interpretation of section 7?
Yeah, okay.
Thank you. Now, what it does seem, doesn't it, Dr. Smith, is that an important part of the statutory mechanism around the Register of the Interests is the existence of a Standing Select Committee. Would you accept that?
I do, yes.
From your own perspective, and I know I'm taking you back in time, but were you a supporter of the Register of Interests Act?
Yes, I was.
And would you accept that a register of interests would only be effective if it was, in fact, an accurate record of people, of legislators' interests?
I agree.
And was it your view that it was ultimately the responsibility of each legislator to file their declarations?
It was the responsibility of each legislator, yes.
You were a party leader. You were at times also, and for a significant period, the Premier. Taking your position as party leader first, did you see that there was any obligation on you as a party leader to encourage those who were in government with you or in opposition with you and from your own party to comply with the Register of Interests Act?
Let me just say that I was not the party leader. I was the, there's another person who was a party leader. I was the president of the party at that time. But still, I did have a responsibility to discuss the matter with members, yes.
Forgive me, that's my ignorance of the structure of the National Democratic Party.
No problem.
Perhaps if I more properly described you as a leading figure in the party. But if you said candidly that there was an obligation to discuss it with members. Did you in fact discuss it with members of your own party and the need for compliance?
I cannot recall exactly what happened, but I'm sure that we discussed it.
And so, and I'm obviously the obligation is on those who are alongside you, members of the House of Assembly. It's not on your party, the wider party. So, if from your recollection, can you say that those who sat alongside you were aware of the need to make declarations on time?
I would think that there would have been, because it was all in the Act.
And turning now to you as Premier and Minister of Finance, from that position, or did you use that position to encourage all members of the House of Assembly to comply with their obligations under the Register of Interests Act?
I can't recall what I would have said to the members of the House of Assembly, but I'm sure I did advise, recommend that they comply with the requirement to declare the interest.
And you may be able to take this from me, but the Act doesn't impose any obligation on a registrar to make or to notify members of the House of Assembly of their obligation to submit on time. It doesn't impose any obligation to send reminders or anything like that. It appears on the Act to simply fall down to it's the legislator's job. They either do it or they don't. Would you accept that?
It seems so, yes.
And so you accepted that the effectiveness of the register depends on compliance. So if there is a culture of non-compliance, that would inevitably, wouldn't it, undermine the effectiveness of the register?
That is correct.
Now, I hope you have in front of you, if you could put the legislation bundle just to one side, please. I'm afraid that the desk is perhaps a little too small for all of the bundles that we've given you, but there should be a bundle dealing with governor's disclosure. If you could just find that bundle, please. Thank you very much, Dr. Smith. Could I ask you just to turn up in that, page 96, please? If I have taken you to the right place, you should be, Dr. Smith, at a memorandum from the Registrar of Interest dated the 19th of February 2014. Do you have that, sir?
Yes.
And if my maths is right, and it is sometimes a big if, in 2014, you would have been Premier and Minister of Finance.
Yes.
This is not a memorandum that is copied to you, but to give context to other documents, another document I want to show you, I want to take it to you first. What it is, Dr. Smith, is a memorandum from the Registrar to the Governor dated the 19th of February 2014, headed Declaration of Interest. And if I...
So it was copied to the Premier.
No, it wasn't. It wasn't copied to the Premier.
It's CC'd on the bottom.
I'm sorry. You're right. Thank you. So it is copied to you. I'm grateful, Commissioner. But what the first paragraph refers to is a meeting between the Registrar and the Governor. And if I pick it up at the second paragraph, it continues, one of the matters we discussed centered on the delinquency of some members of the House of Assembly in filing or not filing their declarations of interest. I'm somewhat embarrassed to inform that there remain some members who have never filed a declaration since taking office on 8th December 2011. I have issued numerous requests and reminders. I have exercised courage and brought this matter to the fore during standing Finance Committee meetings, practically begging members to desist from contravening the statute and to do what is required under Section 3 of the Register of Interest Act. Unfortunately, my pleas have gone unheeded. It is this state of inaction and frustration that prompts me to now inquire whether you would exert some influence at Cabinet level, thereby encouraging members of Cabinet who are also members of the House to respect the requirements of the Register of Interest Act and the Virgin Islands Constitution Order 2007. In this connection, I am hereby copying the Premier for his input. If I could ask you, please, just to turn up page 99, Dr. Smith. This is a memorandum from the Governor dated 9th of July 2014, and it is addressed to you as Premier. The Governor then was Boyd McCleary. It's headed Register of Interest Committee, and it reads as follows. We have spoken several times about the importance of the Register of Interest legislation and of the need for a Register of Interest Committee to be established by the House of Assembly. I attach a letter dated 19th of February 2014 from the Registrar of Interest to the Honourable Ronnie W. Skelton, Chairman of the Standing Orders Committee in the House of Assembly, which spells out the issue in some detail. Mrs. Romney-Varlack notes that in the absence of such a committee, The Act is not fully operational. The Register of Interest remains a vacant book. The Virgin Islands Constitution Order 2007 and the Register of Interest Act 2006 continue to be contravened. I welcome your assurances that the Register of Interest Committee will be established. I trust that this will not be much further delayed. You will find the letter that the Governor refers to, dated 19th of February 2014, at your page 97. Now, it's dated at the top 19th of February 2014, addressed from the Registrar to the Honourable Ronnie W. Skelton, Chairman, Standing Orders Committee. If we look at the bottom, Dr. Smith, it is copied to the Governor, but it is not copied to you. What the letter reads is, I write in connection with the Standing Orders Committee and the draft Standing Orders of the House of Assembly. As you're aware, having been chairman of the Standing Orders Committee for the period August 2003 up to about March 2007, the report of the Standing Orders Committee was laid on the table of the Legislative Council of the Virgin Islands at the 48th sitting of the first session of the 15th Legislative Council on 20th of March 2007. Since then and up to present, there has been no forward motion on the report. You're also aware that the Register of Interest Act was brought into force on 18th February 2008. Simultaneously, the Registrar of Interest was appointed to, among other things, maintain and keep the register in accordance with the Act. Section 4 of the Act speaks as to how the register shall be maintained and, quote, shall be in such format as the committee shall approve, end quote. Section 77A of the draft Standing Orders of the House of Assembly make provision for the Register of Interest Committee. I've no doubt that you can understand how the work of the Registrar of Interest is hampered by the non-existence of the Register of Interest Committee. Since the coming into force of the Act and appointment of the Registrar of Interest, 6+ years have elapsed. The Act is not fully operational. The Register of Interest Committee has not been appointed. The Register of Interest remains a blank book. The Virgin Islands Constitution Order 2007 and the Register of Interest Act 2006 continue to be contravened. All this is hinged on the amendment of the Standing Orders of the House and ultimately the appointment of the Register of Interest Committee. And she now concludes, I now crave your indulgence and seek your advice regarding the appointment of the Register of Interest Committee. Now, this is in 2014. As Mrs. Romney-Varlak points out, the Act comes into force in 2008. It requires, as you've agreed, a standing select committee. And between 2008 and 2014, no such committee has been established. Now, taking that period, 2008 to 2014, you were obviously in government and leading the government. Can you help the Commissioner with this? What difficulties were there in taking this important step of establishing a standing select committee?
I cannot recall a great deal about the discussions, but as I note here, there was a Standing Orders Committee, which would have been the body to introduce it. And I really, quite honestly, I cannot explain or tell you what happened at that point or why it did not get there or what discussions happened.
As Premier and Minister of Finance, you're not chairing the Standing Orders Committee, are you?
No.
But in your experience, and this is as an experienced legislator and a leader in government, does it normally take 6 years to amend standing orders in the House of Assembly?
Sometimes it does take a while, depending on what the subject is.
And can you give the Commissioner an example of what you mean by a while?
Not really. Any committee to be established takes some time because it requires discussion among members. and before we can arrive at a conclusion. Not all the time. Some committees can be established immediately, by the Premier, by the Speaker of the House, but some others can take some time. I cannot give an example of what happened. Of course, this is an example.
Now, 2008 to 2009 actually spans, to 2014, forgive me, spans 2 houses of assembly, doesn't it? It's the second and the third houses of assembly. I mean, again, from your experience, would you consider 6 years to be an unusual period of time, an unusually long period of time to amend standing orders?
I would say that it was considerable time.
Does it, and please say no if you think otherwise, but does it reflect a lack of interest amongst members in making this a priority?
I would not say it reflects a lack of interest. Perhaps I would say it reflects a lack of concern about the consequences of making this fully operational as we expect it to be. And I would say that members would need assurance that their affairs would not be subject to distortions and other activities by members people who would have gotten hold of it. I think that was perhaps the reluctance, but not necessarily that would have stopped it, but that would have been a reluctance, I think.
I didn't take you to this piece of the 2006 Act, Dr. Smith, but I think it's section 9 provides that the Act would not be open to public inspection. And so that gives the reassurance to members that the public can't just walk in and look at what they've declared. And in fact, under section 13, there are very limited circumstances in which the register can be made public. Doesn't the fact that even 6 years after the Act comes into force, the system is not fully operational, doesn't it actually reflect a culture of indifference to the importance of having a register of interests?
I would not say indifference. I would say the importance of the register of interest was accepted. The register of interest was actually put in place, and the question was about the formation of the committee. And I'm sorry I cannot tell you, why in detail why the committee was not established. It's been some time, but as you were saying, it was not established.
As Mr. Roberts explained, under section 3 of the Act, you're in breach of the provisions to make declarations as soon as a declaration is late. But under the Act, there's no sanction for that breach. The sanction falls within section 7, under which, if you are more than 3 months late, the registrar is required, she's mandated to make a report to the standing committee. So those are the only teeth, the only sanction that there is. No select committee, so there's simply no sanction. And the result of no sanction, says Mrs. Romney-Varlak in her letter of the 19th of February 2014, is that the register of interest remains a blank book. So that it seems, at least she considered the select committee to be key in terms of compliance with the Act.
I hear you and I agree with you. And then she's quite right that it was necessary.
So the absence of the committee frustrated the purposes of the Act?
Frustrated the purposes, yes, but it's still, the Act still caused members to produce their returns, albeit not always, at the correct time.
Yes, thank you.
But returns were made.
One of the questions which remains unclear is when the Standing Select Committee was established. The Honourable Julian Fraser has already given evidence to the Commissioner, and I hope I'm not misremembering what he said, but I think my recollection is that he said it was in 2017. The Honourable Melvin Turnbull's recollection was that it was much earlier than that, at the beginning of the Third House of Assembly in 2015. And I wondered if I may, if I could ask your assistance, Dr. Smith, just to establish the particular date. I hope, I'm not asking you, it's not an exercise in memory. I do appreciate it's been some time, but hopefully you will have to your right some loose pieces of paper. Just, yes. Now, they are, just for the transcript, resolution number 3 of 2016 of the House of Assembly, and then 2 articles. If we start with the resolution, which is dated at the bottom as having been passed by the House of Assembly on the 25th day of April 2016, and then recorded being gazetted on the 19th of May 2016. I'm not going to read it all out, but would you agree that what this resolution did, Dr. Smith, was as of the 25th of April 2016, it established understanding orders, a select committee known as the Register of Interests Committee?
That's correct.
And as part of the resolution, it appointed the following then members of the House of Assembly to be members of that committee, and they are as follows: the Honourable Mark Vanterpool as chairman, the Honourable Archibald Christian, the Honourable Marlon Penn, the Honourable Alvira Madura Keynes, the Honourable Julian Fraser, and the Honourable Andrew Foy. Is that right?
That is correct.
And once, if I take you to the second, or to an article which is from the Island Sun. Do you have that, please, Dr. Smith? The article from the Island Sun is dated April 27th, 2016, and it refers to the establishment of this select committee. But if I take you to the third paragraph, which begins Premier and Minister of Finance, what it is recorded at is, it records as follows: Premier and Minister of Finance, Dr. the Honourable D. Orlando Smith, moved the motion and explained that the Register of Interest Standing Select Committee will carry out and exercise all the functions stipulated under the Register of Interest Act 2006. Now, I don't need to read out any more of that report at the moment, but I pause there just to ask you this: is that your recollection that you would have been the person responsible for moving the motion?
I probably did, but I cannot really confirm that because the Standing Orders Committee, the chairman, it falls under that in that line. But if they said I did, then I can't deny it.
Well, a newspaper report can be wrong. Sometimes they are. So it's not a big point. It's more just to, in order to assist the Commissioner with understanding the process of how it works. But once the Standing Select Committee is set up, Is it down to the chairman of that select committee to take its work forward?
It is.
It's not something, even though that moving the motion is attributed to you by the press, when it meets what it does, it wouldn't have been a matter for you just because you were then the Premier and Minister of Finance.
No, once the committee is set up, then the committee will meet under the direction of the head of that committee and in cooperation with the Registrar of Interest.
If I do take you back to the article and the penultimate paragraph, it says as follows: Romney Varlak said that successive throne speeches mentioned the amending of the Act to include senior public servants and make it necessary for such civil servants to make declarations. However, it was noted that such inclusion would require that the Act be replaced and repealed. Do you remember at about the time that the Standing Select Committee was established, which is 2016, that there was discussion about amending the Act to require senior civil servants or senior public servants to make declarations?
I cannot remember any detailed discussion.
Can you remember if at about that time, 2016, there was any discussion about making the register of interest open to the public?
I cannot remember that in 2016, but I know that there has been discussions about whether it should be public or private. Yeah.
If I could take you back now to your bundle, which is the bundle of documents relevant to you, and we just quickly look at the declarations that you filed. If I take you please to page 75, Dr. Smith. This is a page, a registration form for declarations of interest. It's stamped at the top, received July 7th, 2015. Do you see that?
Yes, I do.
And if you go to page 85, this is the last page of this document. It might be a little faint, but can you confirm that that's your signature?
That's correct. Yes.
And it's dated the 25th of June, 2015. Now, the due date was the 23rd of June, 2015. So you were a couple of days out, weren't you? In terms of filing dates. But if you then go to page 64, please. You should have another declaration of interest, and your name is on it at the bottom, stamped July the 6th, 2016. Do you have that? Page 64 at the bottom.
Yeah.
Right. Now, your signature, I hope it's your signature, appears at page 73. You confirm that that's your signature?
Yes, that is my signature.
And it's dated at the bottom, 13th of June, 2016. So remembering that at that time, for that House of Assembly, the due date was the 23rd of June. You had actually submitted before the declaration date. If we go to page 52 now. It's now your 2017 declaration. Stamped June 27th, 2017, with your name and constituency at the bottom of the page. Do you have that, Dr. Smith?
I do have it, yes.
The last page of that is at page 62. Again, please confirm that that's your signature.
That is my signature.
And that's dated the 26th. I think. Well, perhaps I'll leave it to you because I wasn't clear on the date. Is that the 20th of June?
26th of June.
26th of June. So again, I think it's 3 days outside the due date, which was the 23rd of June. But if we go to page 40, please. This is stamped again with the stamp of the Registrar of Interest. She has written in manuscript within the stamp the date 19th of September 2018, and there's your name and your constituency on that. But if you go to page 50, please, could you confirm if that is your signature?
My signature, yes.
Now, the date there is the 4th of September 2018, isn't it, Dr. Smith?
That's correct.
So certainly, what can be clearly said in relation to the 2018 declaration, the due date for that being the 23rd of June 2018, which is the anniversary of the date on which you were sworn into the House of Assembly for that session. You were out by nearly 3 months, so you had failed to submit in accordance with Section 3, hadn't you? Would you accept that?
That is correct, but within the 3 months.
Now, you've in each of these forms, and I'll say this for the record, but you provide details of your interests. They remain unchanged over the 4 years for which we have interest. But can I take you just to one particular part of it, and that is, if you go to page 46, please.
What page?
Page 46, please, Dr.
Okay.
Smith. Now, one of the on the form, one of the paragraphs, it's paragraph 6, requires members of the House of Assembly to give details of overseas visits in specified circumstances. It's not every single visit you ever do, but it's visits that are linked to membership of the House of Assembly, where the cost is not wholly borne by yourself or by public funds. But I wanted to draw your attention to the note at the bottom of the page, which says you are not required to register visits undertaken on behalf of the Commonwealth Parliamentary Association. Other categories of overseas visits which are exempt from the requirement to register are listed in the guidance pamphlet on registration and declaration of members' interests. Now, the declarations that we've looked at that that relate to you, Dr. Smith, have been provided by the Registrar of Interests. But do you remember receiving a guidance pamphlet on registration and declaration of members' interests?
I can't say right now that I do remember that.
And so when it came to filling in the form, what guidance did you have in completing your form?
What I'm saying is I cannot confirm that I did not receive the form or that I received the form, but I must have had some guidance. And also the questions, like for example, question 6 is quite straightforward.
So if we break that down, so I mean, separate to the form itself, you can't remember whether you had a guidance pamphlet or not.
No, I can't remember.
But as you've said, and we're sort of in the middle of the form at the moment, right? We can look back at the beginning, but you said in relation to paragraph 6 that the question seems quite straightforward. From your experience of completing these forms, did you find that they presented, that they appeared uncertain, or I'm just going to start that all over again. Did you find when you had to respond to the questions on the form that it created in your mind any uncertainty or ambiguity about what information you were expected to declare?
There was just one section. I can take you to it.
Yes, please, Dr. Smith.
And like I said, page 61, section 9.
Page 61, for the transcript, you've taken us to the section, which is paragraph 9, which deals with declaring shareholdings.
Yeah, exactly. That I found a little challenging because the companies that I would be involved in, there were no, we call it the 25,000 or less than 25,000. Those are not organized in any such way. And the other thing is that the companies that I was involved in were all mentioned during the preceding paragraph, 3 companies.
I see. Let's put that in context. If you go back to, you've taken us to page 61. If we look at the start of the form, which is at page 53,
Okay.
and I think it's probably not. It's actually 2 that I think we need to look at. Page 654.
Yeah.
So. 1 asks you about directorships, and you've answered that in the negative, and then in 2 you list a medical practice and a property rental company.
Correct.
And so under 9 shareholders, you've listed something called Mhl Holdings. What was the difficulty or what uncertainty or doubt did paragraph 9 create for you?
Okay, I had, as I said, recorded these medical practice, law and property rental in other parts of the document. I had not at that point made any calculations about share value and that kind of stuff. But the Mhl Holdings was a different matter. And maybe I should not have included. This is actually a company that my wife is involved in and has nothing to do with me. But because of this paragraph here, I thought I'd mention it here.
Because what you're asked there is, do you have either yourself or with or on behalf of your spouse or other dependent children interest in shareholdings in any company or body? Yeah. But it's directed to shareholdings in which you have a link.
So I need not have put that.
And so stepping back from the form, and you may not be able to answer this, but you've had the experience of having to complete this form. Stepping back from that, were there areas where you thought it could be clearer in terms of the information it sought?
Well, that particular one could have been clearer.
And that's the one that sticks in your mind, is it?
And that is that. Well, as you notice, I did not fill anything there, but I placed it. It's all through the document otherwise.
Yes. Could I? There is just one and I can show you a document if it helps you, but a company called Picksmith.
Yes.
Did you have any connection with Picksmith?
Yes.
And what was that connection?
I was a shareholder and director of Picksmith, yes.
Now, the declarations that we've seen from you are 2015 to 2018. They make no mention of Picksmith. Was there a reason you didn't mention it?
No, it was mentioned. I'll find it for you. Depends on the time. In 2017 and 18, I was no longer attached or involved with Picksmith.
So certainly after 2017, you wouldn't have had to include it in your...
No, I would have included just US medical practice and law.
But prior to that, you ought to have referenced it.
Prior to that, I would have referenced it. Let me see.
I don't think I need to take the point any further. I think you've helped us clarify that point. If I may, could I just move on to a different topic, please?
Sure,
Dr. Smith, this is a question that I've asked of both now former members of the House of Assembly and current members of the House of Assembly, and it's about exemptions. And there may be a particular dimension to you because of your professional background as a medical practitioner. But I'm going to try and summarize this, but as you probably very well aware, Section 67 of the Constitution deals with the tenure of seats of members of the House of Assembly. It provides in certain circumstances that an elected member has to vacate his or her seat in the House. One of those circumstances, put very simply, is if that elected member becomes a party or is linked to a contract with the government of the Virgin Islands. Now, in those circumstances, the House can, if the circumstances appear just to the House, the House may exempt an elected member from vacating his or her seat. Now, during your time as an elected member, were you ever exempted from vacating your seat under Section 67?
Yes, I did take a request to the House and it was approved. But once it was approved, I did not take it any further, meaning that I did not have a contract at all with the hospital or the health authority after that. Now,
in your case, and please correct me if I'm putting this wrong, but in your case, did that motion arise out of the fact that prior to entering politics, or that you were a practicing medic?
I was a practicing medical person. I was a surgeon, a general surgeon, and lots of other things. But there was only one surgeon at the hospital, even then when I was in office. And there are times when that surgeon needed a break, he needed to go on vacation or something. And I thought I could fill, I was filling those needs before on a ad hoc basis. But I thought we could formalize it. But after it was approved, I decided not to pursue it. And I just continued to, as before, serve when it was necessary.
Thank you. Just the last matter from me, and it's just taking you to your position and role as Premier and Minister of Finance. Obviously, you would have sat in Cabinet for a significant period of time. Could you just tell the Commissioner just how did what was the system during your time in Cabinet for declaring conflicts of interest or interests related to an agenda item before Cabinet?
When there was a matter that affected a particular member, that member would be absent himself from any discussion about that matter.
What the Cabinet Handbook also provides, and I can show you it if it will help, but it allows a member who has any doubt or uncertainty about an interest to come to bring it to the Premier's attention. Did that happen in your experience?
I think those matters like that were always discussed in Cabinet with the member absent. The Mayor brought it to my attention, but then I would have taken it to Cabinet for discussion there.
Now, obviously, aside from yourself as Premier, as a source of advice, were there, during your time in Cabinet, were there other sources of advice that a member could tap into in order to assess whether there was, in fact, a genuine potential or a need to declare an interest?
The Attorney General was always part of the Cabinet sessions, and he would always advise on matters like that.
Thank you. Mr. Commissioner, may I just have a moment, please?
Yes, sir.
Just, it's
A short moment.
a very short moment, I think. I'll just check my notes, but I think, having checked them, that I have no further questions for Dr. Smith. And so could I conclude by once again thanking him for coming this morning to give evidence to the Commission, but also thanking him for the way in which he has given that evidence.
Yes, and may I thank you too, Dr. Smith, both for coming and for giving your evidence so clearly and helpfully. Thank you very much.
I'm glad to be of help.
Thank you. Mr. Commissioner, I would normally ask you to rise for a brief moment, but as I understand it, our next witness is actually not scheduled until 1 o'clock.
Yes.
For various personal reasons. And so if we could just rise now, and then we will resume as soon as the witness is available.
Yes, we'll resume at 1 o'clock, or if he's here earlier, when he arrives. Thank you very much.
Thank you.
Thank you.
Good, thank you. I think the first thing to deal with is the application for Dr. Pickering to be represented by Mr. Hunte.
Yes, Dr. Pickering is here, Commissioner, as is Mr. Hunte QC, who appears on his behalf.
Yes, Mr. Hunte, I've read your application, thank you. It's an application to appear for Dr. Pickering as a witness.
Yes, please.
Yes. Well, I've read the application and I'll grant that application.
But thank you very much.
Thank you very much. Yes, Mr. Robert.
Commissioner, for the transcript, our next witness is Dr. Kedrick Pickering, and can I ask if Dr. Pickering could be sworn, please?
Yes, thank you.
Good afternoon. Would you like to swear an oath or make an affirmation?
Affirm, please.
Could you take the piece of paper in front of you and turn it around?
Do I need to stand?
No, you don't.
Okay. I do solemnly and sincerely and truly declare and affirm that the evidence that I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you, Dr. Pickering.
Thank you, Commissioner. Dr. Pickering, thank you for coming to give evidence to the Commission today. Can we start off with one formality, and that is to ask you, please, to give the Commissioner your full name.
Kedrick Dudley Pickering.
My questions are intended to be short and simple. That doesn't always work out. And if at any time I ask a question which you have difficulty answering, please do ask me to repeat or rephrase it, and I will do so. If you look to your left, you'll see that there are a number of bundles. We may need to look at some of them in due course, but not right now. I'll take you to some of the documents as we go along. Could I ask that you remember, please, to keep your voice up, to speak slowly. The reason for that is that a transcript of this hearing is being made, and it's important to record your answers clearly and accurately. You were asked to attend because you were at one time a member of the House of Assembly, but as with others, you had a life before politics. So could I ask you, please, just to begin by giving the Commissioner an outline of your professional background before you entered politics?
How far back do I go?
I think start from qualifying as a medic, perhaps.
So I qualified as a physician in 1985, University of the West Indies in Kingston, Jamaica, from where I did my internship. And then I returned home and I worked for 2 years in the health system. And then I returned back to University Hospital in Jamaica, where I did my residency and specialized in the field of obstetrics and gynecology. And then returned back home in 1982. And I've practiced in the field of obstetrics and gynecology since 1982.
And to turn to your involvement in politics, is it right that you were elected to what was then the Legislative Council in 1999?
That's correct.
And that was as a member of the National Democratic Party?
That is correct.
And from that time on through to when you ceased to be a member of the House of Assembly, did you represent the 7th District throughout?
I did.
And I think between 2003 and 2007, the NDP was the largest party on the Legislative Council, wasn't it?
Correct.
And then in 2007, when there was the new constitution, you went into opposition, but you returned in 2011 to government. And is it right that you then took on the position of Deputy Premier and Minister of Natural Resources and Labour?
Correct.
And you remained in government following the 2015 election?
Correct.
And what ministerial post, if any, did you hold in that administration?
Same portfolio.
But did you stand in the 2019 election?
I did.
But you were unsuccessful, obviously,
Correct.
at that one. Now, the topic that the Commissioner is investigating at this stage is the question of interests, and particularly interests in relation to membership of the House of Assembly, but also acting as a minister. And one of the issues that has come up is the Register of Interests Act 2006. That provides for a register, but it provides for a register that is not for inspection by the public. Now, during your time as a member of the House of Assembly up to 2019, what was your view on publication of the register?
It was mixed.
And in what way was it mixed, Dr. Pickering?
I think primarily because as a growing society and we were evolving, I think some of these things take time to be able to achieve their full objectives. And so I think that initially remaining private was probably the best approach.
No, you said that things take time to reach their full objectives. What do you consider to be the full objective of a register of interest?
It should be public at some point in time.
We're now, I think the Act came now in 2019. Do you think the point in time has been reached when it could be made public?
I don't know.
You haven't got any view on it at the moment?
No, I don't.
I can take you to the law if it will help you, because obviously you've been out of politics for a little time. The 2006 Act, and do tell me if you want to look at it, but Section 3 of that Act imposed an obligation on each member of the House of Assembly. And that obligation was to make a declaration of your interests on the day that you were sworn into office. Now, obviously, that day would change because it would depend on which House of Assembly was sitting and when it was first sworn in. But once that date had been reached, you then had an obligation to make a similar declaration on the subsequent anniversary. So in each sitting of a House of Assembly, you would probably make about 4 declarations of interest. Was that an obligation that you were aware of, Dr. Pickering?
Yes, I was.
Another obligation that arises, the first thing that follows from that was that if the member of the House of Assembly didn't file on time, then they were in breach of the Act. You're nodding, but unfortunately the transcript can't record your nodding. Is that an agreement to what I've just put, or?
I'm not sure that. Maybe you could rephrase it.
Well, let's take you to the Act, and I'll show you what it says. I think that's the better way to deal with it. You should have a bundle. It's not your bundle, but it's a bundle that's, if you look at the bundles to your left, there's a bundle which is headed Constitution and Legislation bundle. If you open that to page 59.
I prefer to listen.
All right. Well, I'll read it to you. So I think it's important that you have the wording. Now, Section 3(1) provides a member shall make a declaration in the form set out in Schedule 1 within 30 days after this Act comes into force, and thereafter, A, on the date on which he assumes the function of his office, and B, on each subsequent anniversary of that date. So the first obligation is that on the day that you are sworn into office as a member of the House of Assembly, you should make a declaration of interest. And then on the subsequent anniversaries of that date, you should make a declaration of interest. Now you're nodding yes. Again, the transcript can't record the movements of your head. So do you agree with, I mean, do you have any issue with what I've just read out to you from the Act?
No, I don't.
And if a member of the House of Assembly doesn't file a declaration on the date due, they would be in breach of the Act, wouldn't they?
That's what the law says.
We couldn't quite hear you.
Is that what the law says?
Well, that's what I'm suggesting the law says, and nobody has disagreed with me so far.
I don't have any disagreement with that.
Thank you. If the other way in which, or the other obligation that arises or risk to a member of the House of Assembly that arises is under Section 7, because Section 7A provides that if a member fails to make a declaration within a period of 3 months from the date on which the duty to make the declaration accrued, then the member shall be in breach of the provisions of the Act, and the Registrar of Interests is mandated to make a report to the Standing Select Committee. So that's a second way in which a member of the House of Assembly can be in breach. Now, part of the mechanism of this system was a Standing Select Committee. Would you agree that the system is only effective if there is in fact a Standing Select Committee in place?
I agree.
And that the system is only effective if the Register of Interests, even if it is private, is an accurate record of members' individual interests?
I agree.
And in terms of where the responsibility to submit a declaration lay, is it your view that that responsibility fell on each member of the House of Assembly?
Yes.
So it wasn't your role, was it, as a senior member of your party to ensure that there was compliance?
I don't know about that.
Again, your voice is very soft, Dr. Pickering, so if you could just speak up.
Rephrase your question again.
Did you see it, given that you were a senior member of your party, as any part of your role to ensure that other members of the House of Assembly in your party complied with their obligations under the Register of Interest Act?
I guess so.
Did you take any steps to ensure that they did so comply?
Insofar as I did it myself, yes.
But you say insofar as you did it yourself, I mean, how did you spread the word, so to speak? How did you share that with other members of the House of Assembly?
Once I had fulfilled my obligations, I would inquire and remind others simply.
Do you remember that whilst a member of the House of Assembly, that you had correspondence with the Registrar of Interests?
Yes.
Do you remember sending you letters notifying you that the declaration of interest was due?
Yes.
And that were you ever sent reminders or chasers if you did miss the date?
Yes, I was sent reminders, and I was reminded by my secretary too.
Can we look then at some of your declarations, please? And this is the bundle that relates to you alone. If you go, please, to page 63.
I'm listening.
Thank you very much, Dr. Pickering. Well, page 63 is the first page of a Register of Interest Act declaration. It's been stamped by the Registrar of Interest with this date, January the 7th, 2015, and it has your name at the bottom of it. On page 63, can you confirm that's your handwriting?
Page 63?
Yes, please.
Yes.
That's your handwriting. If you then go through to the last page of this document, which you will find at page 73, there's a signature there. Is that your signature?
Yes.
There's a date in manuscript. Is that your hand?
Yes.
Is the date the 7th of January 2015?
Yes, sir.
Now, this declaration is your declaration for 2014, because that House of Assembly was sworn in on the 8th of December 2014, which meant that you had to have that declaration in by the 8th of December 2014. So would you accept that you were therefore late with that declaration?
Yes.
If you go please to page 52 in the bundle. Again, that's stamped by the Registrar of Interest as August the 31st, 2016. It carries your name on the front page. If you go through to page 62, Dr. Pickering. Again, please confirm that that's your signature.
Correct.
And underneath, there's some dates in manuscript. Can you tell the Commissioner which parts of that writing are yours and which belong to somebody else?
The initial is mine.
What about the date? Is that yours? 29th of August, 16.
That is correct.
So the text that says for 23rd of June, 2015, that's not in your hand.
No.
But
No,
that,
sir.
I'm sorry, I spoke over you.
I said no, sir.
That confirms, however, it's likely to be the registrar's handwriting, but it confirms that this is your declaration for 2015, which was due on the 23rd of August 2015, and you've 23rd of June 2015, forgive me. So you have submitted it, it appears, over a year later. So again, would you accept that you failed to submit that declaration on time?
That's correct.
And in fact, that you also fell outside the 3 months that I referred to you to earlier, that's set out in section 7. That's right, isn't it?
That's correct.
If you go now to page 41, this is stamped by the registrar, April 5th, 2017. It's your declaration again. And if we look at page 51, can you confirm that's your signature?
Correct.
The date underneath looks to be the 5th of April, 2017.
Correct.
And what's endorsed, possibly not in your handwriting, is that it's for the 23rd of June, 2016. Is that right?
That's my handwriting, correct.
And so that's your submitted in April 2017. That's your declaration that was due on the 23rd of June, 2016. And so that again is a declaration submitted after the due date, isn't it?
Correct.
It's also a declaration submitted after that 3-month period that I referred to you to, that is set out in section 7.
Correct.
If you go and look, please, at page 40. Sorry, if you go, please, I can do it shortly if I take you to page 38, please, Dr. Pickering. Page 38 is a letter addressed to you, dated the 8th of January 2019, from Victorine Romney Varlack, the Registrar of Interests, and it begins by wishing you and yours a very productive and blessed new year, and then continues, this being my first communication to you for 2019, I fervently hope that I will not have to write to you again for this year regarding the undue declarations of interest that fell due on 23rd of June 2018 and 23rd of June 2017. I encourage you to submit your declarations without further delay. Did you subsequent to that, do you remember submitting further declarations to the registrar?
I honestly do not remember, sir. Don't recall.
But it would appear, wouldn't it, Dr. Pickering, that by the 8th of January 2019, you had also failed to file your declarations for 2017 and 2018. Would you accept that?
It will appear so, but I can't. I don't remember for sure.
But it appears, again, from the declarations that we've seen and this letter, that there were 5 years in a row where you failed to serve your declaration on time, weren't there? 2014 through to 2018. You're nodding again, Dr. Pickering, but unfortunately it's not caught on the transcript. So
yeah, I'm aware now. I can't say that I honestly realized it was like that, but yeah, I'm aware now.
now you say now you're aware, and you didn't realize at the time that it was like that. But why was it like that? How did that situation come about?
It's a good question. I don't know. I can't remember why it happened that way.
But is a possibility that the House of Assembly or the Houses of Assembly that you were a part of simply gave no importance to the Register of Interests?
That's a difficult question, but it could be possible. I mean, I can't. I don't know how to respond to that. It could be, it could be not. I'm being aware of this now. It's difficult to say otherwise.
And would you accept this, that where legislators fail repeatedly to file their declarations in on time, it undermines the whole purpose of the regime, doesn't it?
Yeah, that's correct.
I'm sorry, I didn't quite hear you.
I agree with you.
Now, one of the elements of that is the Standing Select Committee. Dr. Smith gave evidence just before you, and he confirmed that the first time that the Standing Select Committee was established was in April 2016. Were you ever a member of the Standing Select Committee?
No, not that I remember.
So far as you can remember, did you have anything at all to do with the Standing Select Committee?
Not that I can recall.
In terms of what you said in your form, you gave the same answers across all of these forms. And so I'm not going to take you through the detail, but what I'd like to do is just ask you some questions about the form itself. Could you go to page 45, please? This is not a question directed specifically at the answers that you gave or the accuracy of the answers that you gave, Dr. Pickering. It's directed at what you might have understood you were being asked to provide. It's paragraph 4 of the form, and it's headed sponsorship. The first question that a member of the House of Assembly is asked to provide or to answer is, did you benefit from any sponsorship before election where, to your knowledge, the financial support in any case exceeded in aggregate $2,500? At the bottom, if you look, there's some explanatory notes in italics. And note 2 reads, you should register money given to you by your election campaign committee and money spent by your election campaign committee in connection with your election with your permission. Now, what did you, when you came to fill in the form, understand by the term sponsorship before election?
He said that if you were given monies in excess of $2,500, as an aggregate in total.
So did you read it as to encompass donations to a political campaign?
In excess of $2,500.
Yes.
You're asking?
Yes. So if someone came to you and gave you a donation of $2,000, you wouldn't declare that, would you? On
No.
your understanding. But if they gave you a donation to your campaign of 2,500 and above, then that is something that you understood you had to declare.
Yes.
One of the questions that the Commissioner has asked of various witnesses is whether there's any regulation of campaign financing. During the time that you were an election candidate, were there any rules that governed how you as a candidate could finance your campaign?
Not that I was aware of.
If you turn to page 47, please. Paragraph 6 concerns overseas visits. That's not, I'm not going to ask you a question about overseas visits, but I want to direct your attention to the note, which says you are not required to register visits undertaken on behalf of the Commonwealth Parliamentary Association. Other categories of overseas visits which are exempt from the requirement to register are listed in the guidance pamphlet on registration and declarations of members' interests. To your recollection, did you ever receive, Dr. Pickering, a guidance pamphlet on registration and declaration of members' interests?
Not that I can remember.
Other than the explanatory notes in this form, to your recollection, was any other guidance given to you as to how it should be completed?
For what to be completed?
As to how this form should be completed?
The form itself?
Yes.
No.
So now, if I take you, please, to shareholders at page 50.
50?
50, please. You're asked there, do you have either yourself or with or on behalf of your spouse or dependent children interest in shareholdings in any company or body? And then there are thresholds set out for you. Now, one of those that you have listed is BVI Investment Club. Dr. Hubert O'Neill gave evidence yesterday, and he recalled in his evidence that in 2003, an issue had arisen in relation to the BVI Investment Club. If that accords with your recollection, can you assist the Commissioner further with what the issue was in relation to BVI Investment Club?
No, I don't recall that at all.
So you don't recall that coming up in 2003 before the House of Assembly, or what would be the Legislative Council then?
I can't recall. I mean, if you tell me something specific, I might be able to respond, but I can't recall that.
Right. I can't be any more specific because that's pretty much what Dr. O'Neill was able to say. In completing the form, did you yourself consider that any part of it was ambiguous or left room for doubt or uncertainty in what was required?
Most of it was ambiguous.
Did you ever raise that with anyone?
The Registrar of Interest herself, yes.
And did you ever seek to raise it with the Standing Select Committee?
I don't recall if I did that, but I'm sure recall us discussing it internally.
When you say discussing it internally, who discussed it internally?
You know what caucuses?
And that's the NDP caucuses.
Yeah.
Now, if there were, did others share your concerns about the content of the form?
Yes, it was a concern.
If there was a concern, was there any reason why steps were not taken to amend the content of the form?
That would be difficult for me to answer.
Well, you've explained, Dr. Pickering, that this was discussed in caucuses. You've explained that you were not the only one raising concerns. Either everybody just talked about it and then did nothing, or they did something. Was something done? About the concerns over the content of the form?
Nothing that I can recall.
Did the concerns that were discussed, at least within the caucuses, lead to perhaps requests for further guidance to be issued to members of the House of Assembly?
That is a topic that was discussed also.
And what steps were then taken?
Nothing that I can recall.
So it may well have been that these discussions stayed within the sanctity of the caucus and went no further.
Like a lot of things, unfortunately.
Was there any reason that despite there being concerns, no one felt so concerned that they wanted to take further steps?
Can you rephrase?
Well, you've said that there were concerns. Your evidence seems to be that those concerns didn't go beyond the caucus. My question is, if whilst there were concerns, was there any reason it didn't go further?
I don't know why, and like a lot of things, you don't know why.
Was it simply that, at least for the NDP caucus, the register of interest was simply not a priority?
No, I wouldn't say that.
Can you help at all as to why no steps were taken to improve things?
I wish I could, but at this stage, I just can't seem to recall why it wasn't.
Can I move to a different topic, please, Commissioner? You may remember this, Dr. Pickering, but Section 67 of the Constitution of 2007 regulates the tenure of seats of members of the House of Assembly. And it also sets out circumstances in which an elected member of the House of Assembly is obliged to vacate his or her seat. And that includes, to put it in summary, if he or she becomes a party to any contract with the government of the Virgin Islands. Circumstances in which that circumstance, if it arises, has one caveat, and that is that if in the circumstances it appears just to the House of Assembly to do so, the House may exempt that member from vacating his or her seat. Now, during your time as a member of the House of Assembly, were you ever exempted from vacating your seat under Section 67?
I had no reason to.
Now, Dr. O'Neill recalls that there was a different sort of exemption because for him, and he said also for Dr. Smith and yourself, which was that because you were medical practitioners working in public service, there was a different sort of exemption so you could continue to do so. Do you recall that?
Well, I'm not even sure what he said. I don't know to what you refer.
Well, I'm referring to Dr. O'Neill's evidence, and his recollection was that alongside him...
Well, I never heard his evidence. So I don't know what he said.
That's why I'm summarizing it for you.
Mm-hmm.
The point is, either there was an Dr. O'Neill is right, and like him, you were exempted so that you could...
Exempted from what?
Exempted so that you could continue to work as a medic in public service.
You're confusing me. Work as a medic in the public service?
Yes.
Can you explain what that means?
Yes. Dr. O'Neill's evidence was that because of the limited numbers of medical practitioners, and particularly senior medical practitioners within the BVI, exemptions were granted to himself, you, and Dr. Smith. And he gave himself as an example as the only ophthalmologist on the islands. And that, he said, allowed him to then continue working at Peebles Hospital. Dr. Smith's evidence just this morning was that he did bring a motion forward to the House to allow him to work in support of another surgeon's who, if that person was away, then he could step in. But he did not, in fact, do that, but he sought the right to do so. My question to you was, in light of what I hope is a fair summary of the evidence of Dr. O'Neill and Dr. Smith, was whether you were also afforded the same exception.
Well, it's an interesting question because I have worked continually at the hospital since 1986. I ceased to work in the public service before I sought election to the House of Assembly. I have provided services to the hospital as a professional courtesy to my colleagues, for which I have never been financially remunerated. Continually, and I still do it up until this day. I've always made my services available to the hospital at no cost. So I've never been remunerated during my time in the House of Assembly for services. I have hospital privileges. My patients pay me through them privately or through their insurance. But the public service does not, and do I emphasize, does not remunerate me in any financial way. And it has never happened.
Well, the question wasn't really necessarily directed at remuneration. The question was directed as whether there was a need to be exempted, but your evidence seems to be that while sitting as a member of the House of Assembly, no issue arose in relation to your continuing to practice medicine.
No, I never had any, because but you use the word exempted, you know, in the constitutional sense.
That's because that was Dr. O'Neill's
Well,
word.
that's a different issue, but from where I sit, I've always had hospital privileges. You know, and that I can attest to. I've always had hospital privileges. Exempted means, to me, a different issue altogether. I mean, to this day, I still have hospital privileges. And so I don't know if we're talking at cross purposes about exemption and privileges. I don't.
As a medic working in the public sector, do you have a contract to do that?
Absolutely not. No.
Because Section 67.
I'm fully aware of that.
That's where the exemption comes in.
I'm fully aware of that, Commissioner.
So if there's no contract, possibly no exemption required. But in any event, as I understand it, you can't recall ever being exempted.
No, because I never had any reason.
I now understand the reason. Yes.
Yeah, I've never had any reason to.
Yes.
You know, I've never engaged in any direct contractual arrangements with the hospital, but I want to emphasize the point. I have always provided services to the hospital whenever it was necessary as a professional courtesy to my colleagues when they had to travel overseas. For whatever reason, they weren't available. And I still do it to this day. It has been a part of my public service and my public commitment. I want to emphasize that.
Yes. No, I understand that. Thank you.
Thank you, Dr. Pickering. Commissioner, those are my questions. Can I conclude by just thanking Dr. Pickering for coming today and thanking him for the way in which he has given his evidence?
No, can I thank you too, Dr. Pickering, for your time and the way in which you've given your evidence. Mr. Hunt, can I just raise one small point with you, hopefully so that you don't have to come back again. But what I've said to the Attorney General and Silk Legal, who represent other current elected members of the House of Assembly, is that at the end of the evidence in respect of members' interests, which will be on Monday now, I'll hear submissions on any criticisms I might be minded to make as a result of the evidence I've heard. The only criticisms I think that are relevant, certainly with Dr. Pickering, would be in respect of his acceptance that he was late in declaring interests. But is there anything you want to add at this stage in respect of that. There may not be.
Well, thanks for the opportunity, Mr. Commissioner. All I would say is that it seems clear that Dr. Pickering did not deliberately or willfully seek to evade, filing his disclosures.
No,
What you mean?
no, yes, and if I can help in this sense, because we've dealt with this with other witnesses, under Section 3, if you're a day after the date, you're in breach, and then under Section 7, if you're 3 months 1 day late, you're in breach of Section 7. There are no defences of reasonable excuse or anything like that. It's simply you're in breach because of time.
I fully understand that once you're late, you're late.
Exactly.
Right. But the point that I was trying to make is that sometimes we all forget to pay our taxes, but it doesn't mean that we are evading, or that, if you're late in paying your taxes, you're late, but nevertheless, you pay them. Right?
No, I understand that. But this is a statutory obligation which various members, current and past, have not complied with.
Right. But although in the end it did comply. And
Eventually they did comply. Yes. Okay. Good. We'll write to you anyway, Mr. Hunt, but I just wanted to give you an opportunity now so that if you had anything to say, you could say it now.
Fine. Thank you very much.
Okay. Anything else, Mr. Ryan?
No, thank you, sir. Our next witness is due at 2 o'clock, but if I could ask you to rise briefly, once the witness is here, we can start.
Great. Thank you very much.
Thank you.
Both.
Thank you.
Yes, Mr. Rawat.
Good afternoon, Commissioner. Our next witness is Archibald C. Christian. May I ask if Mr. Christian could be sworn, please?
Yes, thank you.
Good afternoon. Would you like to swear an oath or make an affirmation?
Make an affirmation.
If you could turn the piece of paper around.
Yes.
Yeah. Turn it around, sorry, and read what's written. Thank you.
May I remove my mask?
Of course.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Mr. Christian, if you wish to keep your mask off whilst giving evidence, that's not a problem.
Thank you.
It might be easier and more comfortable for you. Can I first of all thank you for coming to give evidence this afternoon? And there are some formalities that I need to deal with. The first of those is to ask you to give the Commissioner your full name.
My name is Archibald Clarence Christian.
Now, I try, not always with success, to keep my questions short and simple. But if ever I fail and you have any difficulty in understanding a question, please do stop me and ask me to repeat it or to rephrase it, and I shall try and do it again.
Okay.
There are a number of bundles in front of you on the desk. You don't have to look at any of them for the time being, but we will go through a number of the documents as we go through your evidence.
Okay.
The last thing to mention to you, and I hope and expect that it won't be a problem for you, but that is to remember, please, to keep your voice up and to please speak slowly. And that's because we are having a transcript made of the hearing. It's obviously very important that we can record your answers as clearly and accurately as possible. Now, the first question I'm going to put to you is one that I've put to every witness who has come to give evidence so far, and who, in particular, those who have served or are serving in the House of Assembly. And that is to ask you if you could just give an outline to the Commissioner of your professional background.
I'm a real estate appraiser by training. I joined the firm of Smithsco Overseas Limited in 1983 as a bookkeeper. I worked in the sales department, and for the last 30 plus years have worked in the appraisal department, and I'm also director and shareholder of the company.
Thank you for that. Now, to move on to your political career, and I'm just going to go through it as quickly as I can, and correct me if I get it wrong as we go along, but you were first elected to the House of Assembly in 2011?
That's correct.
And that was as a member of the National Democratic Party?
That's correct.
And you were re-elected in 2015 again for the same party?
That's correct.
Were you a district or territorial representative?
I was a territorial representative.
Throughout your time in the House?
Throughout my tenure in the House of Assembly.
Thank you. And whilst in the House, did you occupy any ministerial office?
I was the Junior Minister of Tourism.
And you would have been in two Houses of Assembly, the second and the third, so from 2011 to 2015 and 2015 to 2019.
That's correct.
In which of those two administrations were you a junior minister?
In the second term.
Thank you. And did you yourself contest the 2019 election?
No, I retired from politics in 2019.
Thank you. You may have gathered that the topic that the Commissioner is investigating at this stage of the inquiry is the issue of interests, and particularly interests that are held by members of the House of Assembly, but also circumstances in which individuals have to declare such interests.
Mm-hmm.
And one of the points that has come up concerns the Register of Interests of 2006. As you may recall, the current register is private. It is not open to the public for inspection. There are certain circumstances in which it can be inspected. Do you agree with that?
That's correct.
Now, whilst you were in politics, 2011 to 2019, what was your view on publication of the register to the public?
I didn't have any adverse opposition to the register of interest information being made public. I am one of the former politicians that held the view that once we decided to enter into public office, and in particular politics, that our declarations should be made available to the public to a certain point. So I had no opposition to declarations being made public.
You've qualified it by using the phrase "to a certain point."
Yes.
Did you, in your own mind, consider that there were certain limitations that had to be imposed on publication?
Yes, I did.
And what were those limitations?
Even though it has not yet applied to us in the Virgin Islands, I suspect that because we are a very small population, there are certain things about your declaration that can be misconstrued or misinterpreted by members of the public, and it could put you at a disadvantage based on perception.
If you were running for election and you had and you were a serving member of the House of Assembly and your declaration was open to the public, do you think that the requirement to make declarations should extend to candidates for election office in order to ensure that there's no sort of disparity of information?
Certainly I do, because before we actually were elected, we would still have to publish in an official gazette or in your local newspaper certain information about your interest that you hold. And I believe that's the basis on which you would start providing information to the public about your various interests. That would eventually come to more information as you get into the Register of Public Interest declarations.
That's fine, thank you. Now, you won't, there's no reason why you should have heard this, but earlier this morning, at the start of today's hearing, I read into the record a report from the Registrar of Interest, Mrs. Romney Varlak. In that report, which dates from May 2009, she referred to statements from the throne in 2008 of an intent to amend the Register of Interest Act so that it covered public officials. During your time in the House of Assembly, was that ever something that was debated by the House?
I don't recall that we actually had a debate in the House of Assembly regarding any further amendment. We have discussions outside of House of Assembly regarding the possibility that there will be some amendments coming to the current bill or current act.
Now you say outside the House, was that within the NDP caucus?
Correct, yes.
Now, in terms of the efficacy of the Act, would you agree that what's important is that the Register of Interests is, as best as possible, an accurate record of the interests held by members at a particular point in time?
Absolutely.
Now, now that you've left politics, you may have left the detail of various acts and laws behind you. And if you need me to remind you of the Register of Interest Act, please do tell me. But I hope we can take it shortly and you'll be able to confirm what I'm about to put to you.
Okay.
And that is that the Act imposes certain obligations on individual members. The first obligation it imposes is an obligation to make a declaration of your interests on the date that you are sworn into office.
Yes.
And that's something that you recall and remember, is that right? And so if you don't do that, if you don't meet that date, you're in breach of the Act.
Correct.
There's then an obligation to make a declaration on each subsequent anniversary of that date.
Correct.
And again, if you don't make that date, you are in breach of the Act. The third obligation arises when you have missed the date, because under Section 7, if within 3 months of that date you still haven't filed your declaration, you are said, and these are the words of the Act, to be in breach of the Act.
Correct.
And the consequence is that the registrar is then obliged to write a report about your breach to a standing select committee.
Correct.
Now, in terms of complying with those obligations, did the responsibility first and foremost lie on each legislator?
I absolutely believe it rests with each member, yes.
In your time, so which is quite a significant period of time in the legislature, 2011, 2019, and when you started, you may have been seen perhaps as a more junior member of the parliamentary party. But was there guidance given to you about how to fill in the form?
I don't recall that there was any particular guidance given to me. I recall that the Registrar of Interest made herself available should you require guidance. But I don't recall that it was something that was directly put to members and made available.
Did more senior figures in your party take steps to make sure that other members of the party within the House of Assembly were complying with their obligations?
I don't recall.
In terms of the authorities within the House, obviously the House has a Speaker, it has a Deputy Speaker, it has a Clerk to the House. During your time in the House, did those authorities take any steps to remind members of their obligation under the Register of Interest Act?
The Speaker did.
And how did the Speaker do that?
I think she did it by writing to members. And sometimes in instances when we had or on and off meeting with the Speaker on certain matters, she would refer to the fact that she received a letter from the Registrar of Interest advising her that some members were perhaps delinquent in their filings.
Did you yourself receive correspondence during your time from the Registrar?
Yes, I did.
She is, and she hasn't made any kind of statement to the Commissioner, but would you agree that Mrs. Romney-Varlak was assiduous in writing to members, reminding them of their obligation?
She was very assiduous.
Could we look briefly, please, at a number of your declarations and just, and if I explain, Mr. Christian, that what I'm moving on to now is looking at two things. First, how the system worked in terms of people making the dates. And the second is, and which we'll go on to in perhaps a little bit more detail, is how useful the form was to you as a member of the House of Assembly. Okay. If I take you please to page 132 in your bundle.
Yes.
This is the first page of a registration form. So it's the first page of your declaration.
Right.
It's stamped by the Registrar August 11, 2015. You will find the last page of the document at page 162.
Yes.
Can you confirm to the Commissioner that that's your signature?
Yes, it is.
And could you just tell us the date underneath, please?
July 14, 2015.
Now, this is for, I think if my maths is right, it's for the third House of Assembly, which was sworn in on the 23rd of June, 2015. So it would appear that at least for this declaration, you had missed the due date. Would you agree with that?
Yes.
And so because of the way the Act works, you were, by missing the due date, you were in breach of Section 3.
Yes.
If you go, please, to page 141.
Yes.
And to help you, Mr. Christian, we're looking at your 2016 declaration. It's stamped June 21st, 2016 by the registrar. And if you go to 153, sorry, correct that to 151, please.
Yes.
Again, could you confirm that that's your signature?
That is my signature.
And although I think the copy may be a little faint, you've written underneath there June 23rd, 2016.
That's correct.
So the date stamp of the registrar may have been wrong, but in any event, because you had to file by 23rd of June 2016, you have made the required date, haven't you, in 2016?
Correct.
If you now go to the 2017 declaration, which you'll find at page, if you give me a moment, you'll find it at page 130.
Yes.
It's not stamped by the registrar this time, but if we go to page 140.
Yes.
Again, is that your signature?
Yes, it is, Commissioner.
And again, you've put the date there of June 19th, 2017.
Correct.
And so reminding you again, the due date is the 23rd of June, 2017. So in 2017, you've made the due date, haven't you?
Correct.
Your last declaration in that House of Assembly was your 2018 declaration. You'll find the first page of that at page 117.
Commissioner?
Yes.
Yes, correct, I have it.
That's the first page, just so that you can orientate yourself. It's of your 2018 declaration. I take you to where your signature appears, that's at 129.
Yes.
Again, that's your signature, isn't it?
That's correct.
And you've dated it September 20th, 2018.
Correct.
So again, you are now, because of the due date is the 23rd of June, 2018, you have missed the due date, haven't you? You should have got it in by the 23rd of June, 2018, Mr. Christian. Would you accept that?
I would accept that.
Yes. But you are luckily just inside the 3 months, aren't you?
Correct. And I think that would have applied to one of the previous ones that you referred to as well.
Yes,
in June.
Yes, I think I'm not going to suggest to you that you were ever so delinquent, to use the Registrar of Interest's word, that you came within the scope of Section 7.
Thank you.
Now, you should, I hope, have in front of you a loose piece of paper just there. One of the questions that has been canvassed with witnesses is when the Standing Select Committee was established. The Act, although it came into law in 2006, did not come into force until February 2008.
Yes.
And part of the mechanism was a Standing Select Committee. Now, this appears to have been established for the first time in April 2016. You are on what you have in front of you, I hope, is the resolution establishing the Standing Select Committee. Do you see that?
Yes, Commissioner.
You are listed as one of the members of that committee. Again, can you confirm that you were indeed appointed to a Standing Select Committee charged with the Register of Interest?
Yes, Commissioner.
Now, that's in the third House of Assembly.
Correct.
The last House of which you were a member.
Yes, sir. Yes, Commissioner.
In your time as a member of that committee, how often did it meet?
Commissioner, I have the recollection of at least one meeting in 2017 or thereabouts. And then unfortunately afterwards, we were impacted by Hurricane Irma and Maria, and the rest is history.
Now, between April 2016 and the arrival of Hurricane Irma is still a significant period of time.
Correct.
Was there any reason why the committee couldn't meet any earlier?
Commissioner, I couldn't give you an accurate reason. You know, we are always guided by a chairman, and the chairman basically sets the timetable and agenda. So I couldn't give a reason why we didn't have more meetings.
One of the tasks that the committee has to do is to agree the form of the register. It is a requirement under the Act that the registrar enter declarations into a register.
Yes.
But the format of that register falls to the Standing Select Committee to determine.
Yes.
And this was one of the concerns of the registrar expressed before 2016, and she described the register essentially as a blank book. Do you remember at any time that you were a member of the Standing Select Committee determining what form the register should take?
No, Commissioner.
Do you remember the chairman, and the chairman is recorded as the Honourable Mark Vanterpool, ever raising this as something that the committee had to deal with?
I don't recall, Commissioner.
Now, you've acknowledged that the registrar was assiduous in her correspondence to members of the House of Assembly. I want to now look at the form in itself, and we can take any example of that. If we go to page 117, please, Mr. Christian.
Yes.
This is a serious question, but did you find this a difficult form to complete?
Initially, when I got the form and I started to go through it, it did take me some time to understand or try and understand the legal terminologies. In my opinion, it wasn't written in layman's English. So you had to take your time and try and understand what exactly the form was trying to extract from members.
And did you go, you've mentioned that, these are my words, that the registrar's door was open to members if they needed assistance.
Yes.
Was she your first port of call?
Absolutely, she was.
Was there anyone else that you could have gone to for assistance?
I didn't think about anyone else.
Now, if we look at the preamble, which is at 117, it says the main purpose of the Register of Interest is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches, or votes in the House of Assembly, or actions taken in his or her capacity as a member. Now, stepping back from that wording, and you've given evidence about the inquiries you made and your assessment of the form. Stepping back from it, what conclusion did you come to as to the purpose of this form?
My initial reaction to the form was that as an elected member, I needed to disclose whatever interest I held as a private citizen to the public so that the public could understand exactly where my interests were and how I obtained those interests. And so from the beginning of my political life, I didn't have any adverse reactions, nor did I have any objections to making whatever interests I held public.
And so even though you knew it was going to be private, did you operate with that approach in mind?
That's the approach I operated with.
Now, if you go to page 128,
yes.
this is the form. When we obtained these forms from the registrar, but you'll see, and this is in relation to your entry, and this is your 2018 form, it's your entry, or you've got to declare shareholdings. And she has, I'm going to say, she wrote underneath, you need to answer this question more fully. And then that's on the 10th of October 2018. If you just look at page 170 in the same bundle. This is a letter from the 9th of January 2021 in which the 2012, you're right, thank you. But the registrar has acknowledged receipt of your declarations of interest for 2011. And she then says, in perusing the declarations, I note some questions which I believe are incorrectly answered. And she then invites you to visit the office at your earliest convenience.
Yes.
So do you remember her returning declarations to you for more information to be given or for details to be corrected?
Yes, I do remember.
Now, we can jump back to page 117. I don't want to go into the detail of your declarations, Mr. Christian. They are focused on your links, if one likes, to Smith Gore BVI Limited.
Right.
But and I'll take you to pages if you need to see them. But in short, what you set out to do was you put your links to Smith Gore in the form on more than one occasion, didn't you?
Yes, I did.
And if we look at it, you declared, you can see at 118, you declared it as a directorship.
Yes.
At 119, you also declared it as a source of remuneration.
Yes, I did.
And then if you go to 3,
yes,
you in effect said that you or Smith Gore effectively will from time to time undertake appraisals for government bodies.
correct.
And then you have also, if we go to 127, declared shareholdings.
Yes, I did.
So was your approach to the form, or did you approach the form with the appreciation that your association with a company or a source of money outside being a member of assembly may have to be recorded in different ways in different parts of the form? That
was my approach.
Now, you said a few moments ago that you felt that the form could have been written in layman's terms or layman's English.
Layman's English.
Yes.
Yes.
It has the hand of a lawyer when perhaps it could benefit from the hand of a real estate appraiser. Now, for yourself, and again, I'm asking you to step back and just focus on your experience of completing the form. Did you, were there any particular aspects of it which you thought could be improved?
Of the form?
Yes. I mean, it has 10 categories to it. Were there sort of any particular sections or categories where you thought, I'm not quite sure what's being asked of me here, I need more detail?
Yeah. Commissioner, 9 years later, if you look back at the form, yeah, I think I could agree that perhaps some improvements could be made in the way the questions are crafted, so that clearer interpretation could be garnered by the member. But I'm not an expert in crafting these types of documents. So I can only offer my experience based on how I interacted with the form.
Yes, and that's all we can ask for. The form is in fact attached to the statute.
It is.
So the form is a mandated form under the statute. It's how you approached it and how you understood it that Mr. Rowett is asking about.
Correct. Yes.
Can I ask you just to turn to page 124, please? What the form gives you is, as you go through it, there are explanatory notes in italics, which, as the Commissioner pointed out, that the form is part of the Act. You've spoken of the Registrar of Interest as a source of information. But if you look at page 124, the last part of the italicized writing refers to a guidance pamphlet on registration and declaration of members' interests. Do you remember receiving a guidance pamphlet?
No, I don't recall.
Either in the what was your first House of Assembly was 2011, 2015, or the subsequent House of Assembly?
I don't recall.
Now,
I don't know if there's an example of the guidance pamphlet that you can show me, but
no.
I have no recollection.
So is it possible that you may have received it, but you do not now remember receiving
That's
it?
That's possible.
I see.
That's possible.
If you look, and this is just if you go to page 128, no, sorry, 129, please, Mr. Christian.
Yes.
It's the last section of the form. It's headed miscellaneous, and it tells the member of assembly completing the form, if bearing in mind the definition of purpose set out in the introduction to this form, that's the preamble that I took you to earlier, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. Now, when you, in your experience of filling the form, what did you conclude you were being asked to give there?
I thought, Commissioner, that anything outside of what was given in the previous sections of the form, where you declare your interest, your shareholdings, that any other items outside of that should be listed on the miscellaneous. And in my instance, it didn't apply to me, so I didn't fill it in.
Now, the form says, it refers to you have any relevant interests which you consider. Did you, was it your view that that question was directed at you rather than at immediate family?
It could be both, me and a family member.
And if a family member did have a relevant interest, would you have declared it?
Absolutely.
On your understanding?
Based on my principles, I would have declared it.
Can I just take you to another topic, please? And that is section 67 of the Constitution. You may well know the Constitution better than I do, Mr. Christian, but section 67 relates to the tenure of seats of members of the House of Assembly, and it also covers circumstances in which a member may be required to vacate his or her seat. One of those circumstances, put simply, is if that member becomes a party to any contract with the government of the Virgin Islands. Mm-hmm. However, the House can exempt the member from vacating their seat.
Yes.
And the House, it's a discretionary decision of the House, and the House can do so if in the circumstances it appears just to the House of the Assembly. Now, in your case, during your time as a member of the House of Assembly, were you the beneficiary of an exemption under section 67, which meant that you did not have to vacate your seat?
No, Commissioner.
Do you remember being asked to vote on such motions exempting other members from vacating their seat?
Yes, Commissioner.
In those circumstances, and I appreciate it's a little while ago now, but in those circumstances, what information was available to you to help you determine how you would vote on the motion?
Well, we were given a background perspective of the member that was brought before the House for exemption. the area of business or expertise or consultancy that that person would have been provided. And then we would have an open debate on the floor of the House, and then we would vote on the motion.
And when you say we, as in the we that is given information, is that every member of the House of Assembly, irrespective of party, or members of the government?
Members of the House of Assembly, the entire body of the House of Assembly.
Was it the practice in your party to meet in caucus before such a motion in order to determine how you would vote as a group?
We perhaps would have met in caucus to determine the reason why the motion was being brought for that member to be exempt.
And again, I'm asking you to dip back into your memory, but you were a member of the House Assembly across two sessions. How often were these exemptions granted in your experience?
In all two terms, not very often, Commissioner.
Are you able
I recall one occasion. Yes.
And is that so? It's in the very low numbers then.
Yes, absolutely.
Commissioner, may I just have a moment, please? Commissioner, those are my questions. Can I conclude, first of all, by thanking Mr. Christian for coming this afternoon to give evidence to the Commission, but also secondly, to thank him for the way in which he has given that evidence.
Yes.
Thank you, sir.
And can I add to that? My thanks, Mr. Christian, both for coming and the manner in which you've given your evidence very clearly and helpfully. Thank you very much.
Thank you, sir.
Commissioner, our next witness is not due, I think, for some time. I think it's scheduled for 3:30. Obviously, if it's Marlon, the Honourable Marlon Penn, if he arrives earlier, we will of course start as soon as we can after his arrival.
But I'll rise until then.
Thank you.
Thank you very much. Thank you again.
Thank you.
Yes, Mr. Rawat.
Thank you, Commissioner. Before I introduce our next witness, who will be the Honourable Marlon Penn, can I for the record say that Mr. Penn this afternoon is represented by Mr. Daniel Fleegerson Davis of Silk Legal.
Yes, thank you.
Could I ask that the Honourable Penn now be sworn? Yeah, he's not been sworn.
From.
Would you like to swear?
Affirm.
Just read it. No.
No, just read the words on the card. Thank you very much.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be truth, shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Penn.
Thank you, Mr. Penn, and thank you also for coming this afternoon to give evidence to the Commission. A couple of formalities that we need to deal with, as we do with every witness. And the first is to ask you, please, to give the Commissioner your full name.
Marlon Akima Penn.
And your professional address.
Richard Stowe Building, Wickhamski 1, Old Town Tortola.
Thank you. As I tell all witnesses, I try to keep my questions short and simple. I confess that it doesn't always work, but if I ask you a question that you have difficulty understanding, please do stop me and ask me to repeat it or rephrase it, and I'll try and do so.
Okay.
You will have in front of you on the desk a number of bundles. You don't need to look at any of them now, but we will go to some of the documents as we go through your evidence.
Okay.
The last thing to ask you to do is just to keep your voice up and to speak slowly. The microphone in front of you is not there to amplify, but to record.
Okay.
But it's important for the transcript to accurately and clearly record your answers this afternoon. Can I start, as I have done with all witnesses, and that is to ask you just to give an outline of your professional background before you came into politics.
Okay, in '95, I started work at the Department of IT in the government of Virgin Islands as a data entry clerk. I left there in '97 and I went to the Financial Services Department. It was then a department where I was a IT technician. Subsequent to my arrival to the Financial Services Commission, I attained a bachelor's degree in Management Information Systems from the University of Temple in Philadelphia. I subsequently left the financial services in 2011 after gaining a seat in the 8th electoral district. When I left there, I was a technology development manager.
Thank you. You've helpfully confirmed that the first time that you were elected to the Legislative Assembly was in 2011, and that was on behalf of the National Democratic Party.
Correct.
And was it as a representative for the 8th district?
Correct.
And you were then re-elected in 2015 and in 2019?
Correct.
And still throughout you've represented the 8th district?
Correct.
Between 2011, when you were first elected, in 2019, did you hold any ministerial office?
No, I did not.
Since 2019, you've been in opposition.
Yes.
And you are the leader of Her Majesty's Loyal Opposition, is that right?
That is correct.
Thank you. To move on to a topic that I've canvassed with more than one witness now, but it is important to seek your view on it, Mr. Penn. As you may have gathered, one of the matters that the Commissioner is interested in is the Register of Interest Act of 2006 and how it operates as a system. The one aspect of the Act is that the register itself is not available to the public. It is available for inspection under prescribed circumstances, but a member of the public can't just walk in and ask to see it. That's right, isn't it?
That's correct.
Now, what is your view on publishing the register to the public?
I have no personal objections to members' declarations being published publicly. If you ask the question, if we go further than members' personal declarations and you creep into private persons' declarations, then I think we need further conversations among members and further conversation amongst the public. But for me, as a public official, I have no difficulty because that is the life that we've chosen.
Can I break that down a little with you? Taking first the position of members of the House of Assembly, your view is that if you seek election and you are elected to the House, then your declarations of interest should be available to the public.
I take that view.
How long have you held that view?
It's been my view. I had no difficulty when my declarations being made public.
Now, you referred to private individuals' declarations being made public. What did you specifically mean by private individuals?
I mean, if there's any amendments to the register of interest that requires to list private individuals who are not elected members, I think there needs to be a special consideration in terms of how that information is shared with the public.
And by private, do you mean public officers?
No, I don't mean public officers.
Right. So in what circumstances do you think the interests of a private individual might be made public?
Well, I don't know what level of amendments that we're considering for the register of interest. So that's why I'm saying that there needs to be further conversations.
But taking it to, and there has been, and the Commission has heard evidence this morning, or received evidence about that in the past. Yeah. There has been proposals to widen the scope of the 2006 Act to include public officers. Is that something that you're in favour of?
I think once you're in public life, I think those are things need to be considered.
And that's even if you are someone in the civil service who's appointed as a secretary or to any job within the civil service.
Again, the level of detail we have to discuss once we see the level of detail.
But in principle, you would not be against measures that capture the interests of public officers. Oh. I'm going to ask you just to keep your voice up.
No.
Sometimes I think you might nod yes or no, but it's not always recorded on the transcript.
No problem.
Thank you. Would you accept this proposition that the register, whether it is private or public, would only be effective if it is an accurate record of the interests that are declared?
I accept.
And for it to be accurate, it must be up to date, mustn't it?
I accept.
Now, you will, not least because you have been in the House of Assembly for some years, but you may well be familiar with the 2006 Act. And so I hope to take this shortly, but if you need me to take you to the Act and what it prescribes, please do tell me.
No, I'm fine.
There's Section 3 of the Act requires, doesn't it, that as a member of the House of Assembly, you have to make a declaration of your interests on the day that you are sworn.
Correct.
And you are then, that obligation arises on every subsequent anniversary of that date, doesn't it?
Correct.
But there is also a second obligation that arises. And before I go to that, would you agree that if you, under the Act, if you haven't filed by the date that the declaration is due, you are in breach of the Act?
Correct.
And the next obligation that arises comes under Section 7 of the Act. And that Section 7A prescribes that if a member hasn't filed a declaration within 3 months of the date that it's due, then that is a breach of the Act. And that's the wording of the Act itself. It defines that as a breach. And the requirement is that the Registrar of Interest must write a report to the Standing Select Committee. Is that an element of the Act that you are aware of?
I'm aware.
Now, in terms of where those obligations sit, do you accept that it's the responsibility of each legislator to fulfill their declarations in and submit it?
Based on the Act, yes. Right.
You're now a party leader. are there any, in your view, is there any role for party leaders to ensure that members of their party in the House of Assembly have complied with this important regulation?
There's no explicit statutory obligation, but I think leadership comes with responsibility.
And expanding that beyond the party, and without in any way suggesting that you're not a youthful man, but do you see that as a more experienced member of the House, that there is also an obligation there to encourage all other members of the House of Assembly to file on time?
There's no statutory obligation, but again, as I said, leadership has its responsibilities.
Now, if you turn to your bundle, please, Mr. Penn, and to page 1 of the bundle.
Which is the same one that you sent to me?
Yes,
Okay.
that's right. You should, if I've taken you to the right page, have a letter dated the 19th of February 2021. I think you've got the index. If you turn through, the pages start, and you should have the pages in the bottom center.
Excuse me.
And if you look at page 1,
I have it, yes.
yes, at the top there's the date 19th of February 2021. And it sets out, it's a request addressed to you as a member of the House of Assembly. And it concerns the 2006 Act. And at the beginning, at the bottom of the page rather, the letter sets out a number of requests from the Commissioner. The first is to give the date and content of each declaration of interest you've made. The second is, irrespective of it making any such declarations, and that's on the next page, to give the information and documents that you would provide in such a declaration if it had to be made as of the date of the letter. And the third is, asks this: if during your period of appointment as a member you failed at any time to comply with your obligation to make such a declaration, in respect of each such failure, a full explanation as to why you did not make such declaration. Now, that letter was sent to you, as I said, on the 19th of February 2021. Was there any reason why you decided not to reply to it?
We had a meeting similar, discussing this letter particularly. I was under the impression at the time that the legal representative through the RIU would respond on our behalf, because we were advised that we didn't have the legal parameters to get that information from the Register of Interest.
See, so the advice given to you was that you couldn't get the information sent, you couldn't consent to the information being sent from the Register of Interest.
Yeah, subject to why we made the amendment shortly thereafter of the Register of Interest.
And that's the amendment that to the Act that allows a Commission of Inquiry to access the register.
Yes.
Did you vote in favour of that amendment?
Yes, I did.
But if you look back at page 2, Mr. Penn, the letter asks for more than that.
Mm-hmm.
It asks you, irrespective of the declarations, irrespective of the forms that you submitted to the registrar, it asked for the information and the documents that you would provide. Now, that's not something that the registrar can help with. It's something that comes from you. Was there any reason that you didn't feel able to answer that question?
No.
But you didn't answer the question?
No, I did not.
Was there any reason, was it a question that you could have answered at the time?
At the time, the documentation prior to 2017, I did not have. Probably could have answered with the subsequent documentation, but I didn't.
It may be the way I phrased the question, but if you look again at the request number 2 from the Commissioner, what the Commissioner was asking was, if you now, as of 19th of February 2021, had to make a declaration, what information and documents would you provide to a registrar?
Okay.
That was something that you could have complied with, wasn't it?
Probably, yes.
And what 3 was asking was that if at any time you'd failed with your obligation to make a declaration to the registrar, could you give an explanation of that failure? That was something that you could have given to the Commissioner, wasn't it?
You could have, yeah.
Could we look, please, at some of the declarations of interest that you did file with the registrar? And if I could explain, Mr. Penn, and this is an explanation I've given to a number of witnesses. Firstly, the commissioner is, and the purpose of my question is to assist the commissioner with understanding the system that operates now and has operated in relation to the Register of Interest Act. And so there are two aspects to that in my questions, and two parts of what the questions that I'll be asking. The first is to look at how members complied, but the second, which we will come to, is to ask individual members of the House of Assembly how they approached the form when they had to answer questions on it. So if I take the first aspect first, and I ask you please to turn up page 165 in your bundle. This is a document which is it's a declaration form. It's the first page of it, and it has your name at the bottom and your district. It's stamped as being received on February the 21st, 2017 by the registrar. If you go please to page 175. You have signed that, haven't you? That's your signature.
Yes, my signature.
And underneath, the writing in relation to the dates, is that in your hand?
Yes, it is.
And what you've written is 21st of February 2017?
Yes.
For 8th of December 2013?
Yes, it is.
And so were you, as of the 21st of February 2017, submitting a declaration that was actually due on the 8th of December 2013?
Yes.
And so doesn't it follow that you clearly were in breach of the Act, weren't you?
Yes.
So you had missed, and in two ways, you had missed the due date, December 2013, and you were also in breach of Section 7. That's right, isn't it?
Yes.
If we go through, and please go to page 154. This is, as we'll see in a moment, your declaration for 2014. Do you have the page, Mr. Penn?
Yes, I do.
Thank you. It's stamped as received by the registrar on February 21st, 2017. Again, it carries your name and district. And if you turn through to page 164, you have signed and dated the document, haven't you?
Yes, I have.
And what you have written is 21st of February 2017 for 8th December 2014. So does it follow, and do you accept, Mr. Penn, that in relation to your 8th of December, or your 2014 declaration, you were in breach both of Section 3 and of Section 7?
I accept.
If you go through to page 144, please. Again, a declaration form stamped received February 21st, 2017, with your name and district recorded on the front page. If you turn through to page 153, again, you have signed and dated that form, haven't you, Mr. Penn?
Yes.
And the date that you have written there, please confirm, is the 21st of February 2017 for 8th December 2015.
Correct.
And so that is your 2015 declaration being made. And again, you were in breach of Section 3 and Section 7, weren't you?
I confirm. Yeah.
If you go please to page 133. This is your, it's stamped again, it's a declaration form with your name and district on it. It's stamped February 21st, 2017. If you go please to page 143. Again, this is the last page of the document. It carries your signature and you've dated it, haven't you?
Correct.
And you have dated this one, 21st of February 2017 for 8th December 2016. So once again, do you accept that this, your 2016 declaration, was filed in breach of Sections 3 and 7 of the 2006 Act?
I accept.
Now I'm going to pause there, because what we have is that on one date, the 21st of February 2017, you filed 4 declarations, and you filed them all late, didn't you?
I accept.
Now, if you look, there should be, I hope, a loose piece of paper on the table in front of you.
No. No.
Resolution. You've been handed, Mr. Penn, a resolution. It's resolution number 3 of 2016. It's the resolution of the House of Assembly of the Virgin Islands, which resolved on the 25th of April 2016 to do 2 things. The first was to establish a standing select committee known as the Register of Interest Committee. And the second was to appoint a number of members to that committee, and you were included amongst those. Is that right?
That is correct.
Now, established on the 25th day of April 2016, at the time that you were appointed to that committee, did you disclose to anyone that you had not filed a declaration of interest for some 4 years?
I don't think I did.
3 years, I'm sorry.
I don't think I did, no.
To your recollection, and this is a committee established in the second House of Assembly, so the 2011, sorry, the third House, it's the 2015 to 19 session. How often did that select committee meet?
I recall one particular meeting.
And what was discussed at that meeting?
It was in 2017. I don't recall the specifics of the meeting. I think I really can't. I don't want to say it. I don't recall specifics.
I appreciate it some time ago, but doing the best that you can. Do you remember if the committee was asked to discuss the form of the register itself?
I honestly cannot recall.
And after that 2017 meeting, were there any other meetings to your recollection?
None to my recollection.
Did you, were you aware that one purpose of the meeting was to consider, one purpose of the committee was to consider reports submitted to it by the registrar?
I can't recall, to be honest.
Did you, when the committee did meet, reveal to anyone else on the committee that you had been delinquent for a number of years in terms of submitting declarations of interest?
Not the members of the committee, but the register was aware.
The registrar was aware.
Because by that time I already filed my declarations.
I see. Can I come back to the awareness of the registrar in a moment? Now, and I'll just return, if I may, just to your subsequent declarations. If we go, please, to page 132. Oh, sorry, if you give me a moment, yes, it's 122, please. This is a declaration. It has your full name typed on it and your district. It's got the stamp of the registrar. She has written in manuscript the date 16th of February 2021. If you go, please, to page 132, Mr. Penn. That's your signature, isn't it?
Yes, it is.
And the date in typescript underneath is the 16th of February 2021, but what's added is for filing 23rd June 2017. So it would seem that you filed your 2017 declaration on the 16th of February 2021. Is that right?
Correct.
So once again, do you accept that you were in breach of sections 3 and 7 of the 2006 Act?
I accept.
If you go, please, to page 111. This is, I'm going to suggest, your 2018 declaration, but it is stamped by the registrar and dated 16th of February 2021. If you go to page 121, that has your signature, doesn't it?
It does.
And you have dated it, it's typed 16th of February 2021 for filing 23rd of June 2018.
Correct.
So your 2018 declaration was again late, and you were again in breach of section 3 and 7 of the Act. Is that right?
Correct.
If you go to page 100, another declaration of interest form from you, stamped by the registrar and dated the 16th of February 2021. If we go through to page 110, that again is signed by you and dated, isn't it?
Yes, correct.
The date that you have given is 16th of February 2021 for filing 12th of March 2019. So we are now in a new House of Assembly, aren't we? So the due date has changed. But once again, would you accept that you are in breach of sections 3 and 7 of the Act?
I accept.
The next declaration of interest that you filed is found at page 89. Your name and your district appear on this. It's stamped by the registrar, again dated the 16th of February 2021. And we see at page 99, that's your signature, isn't it, Mr. Penn?
Yes, correct.
You've dated it 16th of February 2021 for filing 12th of March 2021. 2020, forgive me. So you filed your 2020 declaration on that date. And again, you were in breach of sections 3 and 7 of the Act, weren't you?
Correct.
Now, let's deal with your last and most recent declaration, which you'll find at page 77. stamped by the registrar, dated in manuscript 25th of May 2021. If you go to page 87, you have signed it on that page, haven't you? That's your signature.
Correct.
And you have dated it, and it's typed 25th of May 2021 for filing 12th of March 2021. So you were 2 months late with that. So that you would accept would be a breach of section 3, wouldn't it?
I won't accept this one, and I'll explain.
Is that because for personal reasons, the registrar was unavailable?
No, it's not.
All right, please explain.
First of all, I want to publicly acknowledge my previous breaches concerning late filing and breach of the sections that you outlined. I additionally want to make a public apology to the public as well for not adhering to my statutory responsibility, which I take full responsibility for, and I'm not making any excuses for. What I will, however, note for the 2021 filing is that I have an email correspondence here from our administration, my secretary, to the registrar on the 10th of March 2021, affixing the 2021 filing. So the 2021 filing was indeed submitted ahead of the 2021 deadline. And I've made the necessary adjustments to ensure that going forward, all my statutory obligations are filed on time and within allotted periods as prescribed by the law.
Would you be willing to provide the Commissioner with that piece of correspondence?
Yes, I will. I have it right there printed, and I have also the declaration that was attached with the email.
Well, if we can take that today, that would be very helpful. Thank you. Now, what does show, though, is that as of the 16th of February 2021, you filed 4 declarations covering the years 2017 to 2020. What was it that prompted that burst of activity?
And the recent filings?
Yeah, no, leave aside your 2021 declaration, but you filed 4 on the 16th of February 2021, didn't you?
Yes, I did.
What was it that prompted you to do all of that activity on that date?
A follow-up notice from the registrar outlining that these declarations were in abeyance.
You should, I hope, on your table have a file, not your own file. It might be labeled something like disclosure from the governor. If you turn to page 25 in that bundle, there is there a letter dated the 19th of January 2016 addressed to you from the registrar. And in that case, she was reminding you of the fact that you had not filed at that time declarations for 2013, 2014, and 2015. The correspondence goes through, Mr. Penn, to page 51. I'm not going to take you through every single letter, but it starts at page 25, ends at page 51 with a letter on the 18th of August 2020, reminding you then of the need, to use the registrar's words, your delinquent declarations of interest for the periods 12th of March 2020, 12th of March 2019, 23rd of June 2018, 23rd of June 2017. By all means, leaf through this correspondence, but it's right, isn't it, that the registrar repeatedly wrote to you, reminding you of your obligation to submit declarations on time, didn't she?
Correct.
And it's right that she repeatedly sent you chasers reminding you that you had failed to submit your declaration on time.
Correct.
Did you enter into correspondence with the registrar yourself?
Yes, I called the registrar to get this situation rectified.
But you seem to have rectified your non-compliance, your delinquency, which is the registrar's words, in sort of 4-year bursts. So you did 2013 to 2016 in 2017, and then 2017 to 2020 in 2021.
Mm-hmm.
Were there specific events that caused you in those years to take the action that you had repeatedly declined to do?
No, I can't say that there were any specific events.
Now, I drew your attention to the resolution which appointed you as a member of the select committee, the Register of Interest Committee in the last House of Assembly, the third House.
Mm-hmm.
The Commissioner has received evidence from other members of the House Assembly that in this House, the fourth House, a standing select committee has been established again. Is that right?
Yes, that's correct.
Can you remember when it was set up?
I think I had that information somewhere. On the 9th of September.
9th of September.
Sorry, the 2nd of September, 2019.
Yes. I think that information I think came from the Honourable Neville Smith, who said that it was the resolution was the 2nd of September, and then it was gazetted on the 12th of September 1919.
Yes, that's correct.
With your recollection.
That's correct.
And others have said, and can you confirm that you were appointed a member of that committee?
Correct.
How often since the 12th of September 2019 has the committee met?
I don't recall the committee having a meeting as yet.
Has there been any discussion outside the formality of a meeting as to what form the register should take?
I have not had such discussions.
You allowed yourself to be nominated to a committee in the third House in 2016 when you were non-compliant with your own obligations. You allowed yourself to be nominated in 2019 to a committee in this House when again you were still non-compliant with your obligations. Did you not anticipate or see that there could be a conflict of interest for you in allowing your name to be put forward?
And that I anticipated?
Or did you not see that there could be a conflict of interest?
Possibly.
Why then did you allow your name to continue to be put forward on those two occasions?
No, I have no reason.
I mean, if the committee had asked the registrar to provide a report outlining the extent to which members were compliant, without going into details of what they had declared to her, but simply whether they had submitted by due dates, you would have been in a very difficult position, wouldn't you?
Yes, I would.
And for people who are on the committee, who've been nominated to the committee, there is another difficult position, isn't there? Because it's beneficial to them that the committee should not meet and should not take action. Isn't that right?
I won't subscribe to that particular position, because my intention was never to be a nefarious activity, no nefarious means for me not ratifying my declarations. So, I mean, I had no interest in the committee not meeting.
Have you ever called for a meeting of the committee?
No, I have not.
Either in the third, well, you were a member of the third House, or whilst you're now a current member of the fourth House?
We discussed the possibility of a meeting in the previous committee, yes, which we had a subsequent meeting.
That was in the
2017,
2015, the 2015 to 19 House. Is that right?
Yes.
Which I've been calling the third house. I hope I've
Yeah.
got that right.
Yeah.
But taking your level of compliance, Mr. Penn, it might be suggested to the Commissioner that the way you have conducted yourself shows a lack of regard for a statutory obligation imposed on all members of the House of Assembly. Would you accept that?
I wouldn't accept that. That's a lack of regard. I was delinquent. I have admitted to my delinquency. I have made steps to correct my delinquency going forward, and I am going to continue on that path.
The Act came into force in 2008. A committee was not established until 2016. So in the absence of a committee, there was no one that the registrar could write a report to. On your evidence, since 2016, the committee has met once. It has never sought or asked or received a report from the registrar. Would you accept that the system that is in place is not working?
I can't say that the chairman haven't sought or seek the report from the registrar.
Which chairman did you have in mind?
The one that met in 2017.
Right, and that was, I mean, it's on the resolution, but it was the Honourable Mark van der Poel.
Yes.
But do you remember the Honourable van der Poel putting a report in front of you when you met that one occasion in 2017?
I can't recall the documents that were shared that day.
But insofar as you can recall, in this session of the House of Assembly, you haven't received any reports, have you?
Not in this House of Assembly, no.
And the point, it comes back to the same point though, doesn't it? Would you accept that the system is just not working?
System can be improved, yes.
Well, as other members of the House of Assembly have told the Commissioner, everything can be improved. But before we get on to improvements, do you accept that the system is not working?
I accept there are some issues with the system, yes.
Well, do you accept that in fact the system has never worked?
I can't accept that fact. It's true for all members.
Well, let's keep it to you. You have been seriously delinquent for years, and no sanctions have been imposed against you, have they?
No.
And isn't that just an example of the fact that the system just does not work and never has worked?
You could say that, yes.
Well, I could say that. Well, what do you say, Mr. Penn?
Probably.
Why does it make it? Why do you qualify your answer with the word probably?
It could be. You could say that, yes.
Well, do you think that a system in which a member of the House of Assembly can wait 4 years before submitting their declarations of interest is a system that is working effectively?
I accept that it's not working effectively.
I'll leave it there. Can I ask the second aspect now, which is actually questions about the form as you filled them in? We can take any example of form, and let's go to page 77.
Okay.
And I'm going to just draw your attention to the preamble on the form, which says the main purpose of the Register of Interest is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches, or votes in the House of Assembly, or actions taken in his or her capacity as a member. You have now submitted during your time in the House of Assembly 9 forms. When you approach filling in the form, what do you take to be the purpose of completing that form, having regard to the wording in the preamble?
I take it that based on the 10 paragraphs and the preamble that speaks to any pecuniary interest or material benefit members receive, that it needs to be listed based on the paragraphs listed within the form.
Would you accept that if you are completing the form diligently, then one thing that you need to have regard is what others may think because it says reasonably thought by others. So you have to imagine, don't you, what would somebody else think about a particular interest of mine? And if you keep that in mind, then that guides what you put in the form, doesn't it?
Yes, specific to the paragraphs, yes.
Now, you've said specific to the paragraphs. Could I take you to page 87, please? I'm going to refer you to paragraph 10, but before I do, can I draw your attention to the declaration that each member of the House of Assembly is asked to sign, which reads as follows. I declare that the information contained in this declaration is a complete and accurate description of all interests that I am liable to declare under the Register of Interests Act 2006. Is it right that in completing, or let me put it this way, when you completed these forms, did you appreciate the importance of those words, of that endorsement?
Which you could repeat that again, the declaration itself?
Yes, there is a declaration above the signature, which I've just read out. It's the same declaration in every form. But did you, in completing your forms, appreciate the importance of that declaration?
Yes, I did.
Now, going back to your answer just a moment ago about the preamble, 10 is headed miscellaneous. And it asks you if, bearing in mind the definition of purpose set out in the introduction to this form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. Now, when you look at 10, what do you think that paragraph is directed to?
If I have any interests, or pecuniary interests or otherwise, that doesn't fall within the 9 categories before.
Now you say is if I have, do
Yes.
you think it is restricted to interests that you yourself hold or interests that are also held by immediate family?
It says you, it says from you that you hold. So I take it to mean specifically me.
Right. Now, this goes back to the point I made earlier about how members of the House of Assembly approach these forms. In yourself completing the form, did you find it a particularly difficult form to complete?
The initial forms that I completed, I did them with the assistance of the registrar. So I explained to the registrar whatever my situation was, and she helped me go through the process with the forms. So it wasn't difficult in that regard.
And when completing it, and you've spoken of the 10 paragraphs, but do you think that there are aspects of the wording of the form that create uncertainty or doubt for members of the House of Assembly as to what is required of them?
For me, after the explanation of the registrar, no.
Could you turn to page 83, please? This is the section on overseas visit. That's not what I've taken you to the page about, but do you see the note at the bottom? The last sentence refers to other categories of overseas visits. Do you have that?
Yes, I have.
It also refers to the guidance pamphlet on registration and declarations of members' interests. Now, you came into the House of Assembly in 2011. When you came into the House in 2011, did you, when you arrived, receive a guidance pamphlet?
No, I can't recall that I did.
When you came back into the House in 2019, or when you came in 2015, did you receive a guidance pamphlet?
No, I received form, but not a pamphlet.
Have you ever received a pamphlet?
I can't recall receiving a pamphlet.
Now, you've spoken of guidance being given by you, to you by the registrar, because you spoke to her about completing your form, didn't you?
Yeah.
And there's obviously guidance notes within the form itself.
Yes, there are.
But was there any other source of guidance available to you as a member of the House of Assembly at any time?
No, I followed the guidance from the registrar that was given to me in person.
Now, through all 9 forms, you have in fact answered no to every single question. And so can I just ask two questions about that. I don't want to go through every paragraph and confirm your answers. You have answered no to everything. But if we look, please, at 85 and paragraph 8 and land, it says, do you have any land other than any home used solely for the personal residential purposes of you or your family? And it then says, if yes, please indicate below the nature of the land. Now, obviously, would you accept that you're not required to declare your personal home?
That's correct.
And so in answering no, were you declaring that aside from a personal home, you have no other interest in land?
No, I don't, because I don't.
Right. If I ask you just to turn back, please, to paragraph 4. And this question is not directed to the answer that you put to that paragraph, but it's the heading is sponsorship. And it's this. If you look at A, it says, did you benefit from any sponsorship before election where, to your knowledge, the financial support in any case exceeded in aggregate $2,500? And there's, I won't read it out, but if you look at the bottom of the note, there's a note there too that refers to election campaign committee. Mm-hmm. Now, my question is this: what do you understand to be meant by the term sponsorship before election?
I take that to mean any sponsorship or donation or any in financial or in kind that is given with that dollar amount or above. So
sponsorship in your mind encompasses financial donations to the campaign?
I think while there's a different definition for both, I think the intent is that to cover both of them.
But do you think that that intent could be made clearer to members of the House of Assembly if the form were amended to make sure that to tell members of the House that it included donations that they received?
It could.
Because what you're asked is to list your sponsor. And so if it included donations, there would be a requirement to list donors who gave you more than $2,500, wouldn't they?
Yes, it would.
And from your answer, if anyone in your campaigns had given you a financial donation or an in-kind donation above $2,500, you would have listed it there.
Yes, I would.
Could I ask you, there's a small grey bundle, if you look just at that bundle, please. If I explain to you what this bundle is, it's a request was made of the Cabinet Secretary to produce, under cover of affidavit, election notices published in the Official Gazette. Clearly, as it is open to election candidates to publish their declarations elsewhere. But I want to draw your attention to 2 pages which refer to you. Mm-hmm. The first is at page 18. If you give me a moment, please. Sorry, page 16. 16. If you look at the top, Mr. Penn, you've got, it's the Gazette from the 10th of October 2011. So this is from when you first ran for elected office. Mm-hmm. And there's a declaration there. And one of the, what you say is, I give notice I'm connected with the following company association in the capacity as indicated. And it's one of them is you say, Mhl Holdings Limited member.
Yes.
Now, if you turn through to 256, in the bundle. We're now, I hope, on the 7th of February 2019. So the most recent election notice that you had to file. Mm-hmm. And it refers there to the Nottingham Investment Club. Mm-hmm. Now, just for completeness, two things. Is the Nottingham Investment Club the same thing as NI
Yes,
Holdings?
it's the same thing. That was a typo. It should have been Nottingham Investment Club.
I see. And obviously, is it something that you were a member of and you have been a member of throughout your tenure as in the House of Assembly?
Yes, I am a member, but it's inactive.
I see. And has it always been inactive?
It's been inactive since I've been elected, yes.
And is that the reason why you didn't record it in your declarations?
Yes, that's the reason why.
Thank you. Could I just move to a different topic, if I may? And it might be that you'll be able to deal with my questions very swiftly. And it's this: if you pick up the larger bundle. If you turn to page 88, please. And if I explain, Mr. Penn, this is a set of cabinet minutes, and specifically they're cabinet minutes produced by the cabinet secretaries, Ms. Sandra Ward, that relate to declarations of interest. Now, 88, it's a cabinet minute from the 20th of February 2019. I'll wait for you to turn up the page. Let me know when you have it.
There.
You're there, thank you. Cabinet meeting 20th of February 2019. Now listed there is the Honourable Marlon A. Penn, and it's Minister for Health and Social Development.
Yes.
Was that you?
Yes, it was.
Yeah, the reason I asked to check is because I think earlier you said you hadn't held ministerial office.
And you asked me of 2011.
Okay, well,
You didn't ask beyond that. You asked specifically for 2011.
Then that is my fault. So between 2011 and 2015, you didn't hold ministerial office. Between 2015 and 2019, which ministerial office did you hold?
I was junior minister for trade, and then 4 months in, just before the last general election, I was made Minister for Health.
Thank you for that clarification. If we look at page 88, and I'll explain now that you've given that clarification, the purpose of my questions, which is about how ministers, or the process by which, when you're sitting in cabinet, you have to declare an interest. So stepping back from the detail of the page itself, when you went into cabinet, except it was for 4 months, but what did you understand the process to be if you had to declare an interest in an item?
I will notify the Premier. At the meeting, declare my interest.
And would you then stay in the meeting or would you leave?
Leave.
If you had any doubts or uncertainty over whether there was a conflict to be declared, who would you go to?
The Attorney General or the Cabinet Secretary.
In page 88, and I need to just ask you just to give me a moment. I think there's a typo in my notes, so no, there isn't. If I could ask you to turn to page 113, please. It's the same cabinet meeting. What we have here is, and I just want you to confirm this for the record, but it's part of that same minute that I took you to, page 113. There's the Deputy Premier and Minister for Natural Resources and Labour introduced a memorandum that is recorded as request to lease Crown property, and it's Crown property on Beef Island. And it's a request from you, isn't it, Marlon Penn?
Yes, it is.
And you then recused yourself from the meeting for discussion because it was a matter involving your interest in the matter.
Yes, it was.
So did you just step out of it?
Yeah, I left the room, yes.
Right. Now, what Cabinet did was to grant approval to you to lease that piece of land. Did that transaction in fact go through?
No, it never did.
I see. And is that the reason why it doesn't appear on your declaration?
Yes.
If you turn, please, to page 150. We're now at the 24th of February 2019 meeting of Cabinet. If you go to 167, there is a round robin which seeks a variation of lease, and it's in relation to Ephraim Penn. Do you see that?
Yes.
It was the Minister for Natural Resources and Labour presented this via round robin. And if we go over to the next page, you as Minister for Health and Social Development declared an interest and did not sign the round robin. Is that right?
Yes.
Now, that was a decision that permission be granted to Ephraim Penn to assign his leasehold interest in land in Beef Island to Trellis Bay Market Bar and Grill. What was the nature of your relationship, or what is the nature of your relationship with Ephraim Penn?
That is my dad, and he's had that lease. My family has had that property in their name for decades.
Now, the reason for drawing your attention to this is wider than just confirming the detail. When you were sat in Cabinet, in terms of the ambit of interest that you had to declare, I mean, obviously, we've shown an example where you declared your own personal interest. This is one where the connection is to your father. But in terms of family interest, were you given any advice as to how wide it would be?
No, the discussion surrounding my immediate family.
And what did you take to mean it was meant by the phrase immediate family?
Wife, spouse, children.
And from the fact that you took this step, it would include your parents, and would it include your parents on your wife's side, on a spouse side, in your view?
Yes, it would.
Would it include interests held by adult siblings? If you, for example, you had a brother and they were the subject of the round robin, would you have declared an interest in those circumstances?
Yes, I would have left the room, yes.
Yeah. And again, is that a situation where if there's doubt and uncertainty, the expectation would be that you raise it with either the Premier, the AG, or the CABSEC?
Yes, I would.
I just want to move on now to another topic, please. And that is a question I have asked of more than one member of the House of Assembly. But you will be aware, Mr. Penn, of Section 67 of the Constitution,
yes,
which governs the tenure of seats of members of the House of Assembly. It prescribes certain circumstances in which a member of the House has to vacate his or her seat. One of those is if, and I'm summarizing it, if he or she becomes a party to any contract with the government of the Virgin Islands. That is subject, though, to an exemption, in that if in circumstances it appears just to the House of Assembly to do so, the House may exempt any elected member from vacating his or her seat. Now, first question is whether you, as a member of the House of Assembly, at any time during from 2011 to now, when you have held a seat, have you ever been exempted from vacating your seat under Section 67?
Yes, in 2012.
And can you just explain to the Commissioner the circumstances in which that arose?
Okay. In 2011, when I was first elected, I was employed with the Financial Services Commission as the Technology Development Manager. We were just in the process of digitizing the entire Commission's operations through a mission-critical system called the Virgin System, which is the Registry and Regulatory Information Network of the Financial Services Commission, which is what drives the Financial Services Commission's operations. I was at that time, before he being elected to office, I was the lead person on phases 1 and 2. I actually was a deputy lead on phase 1 and the lead on phase 2. And just before my election, the commission was about to go live with phase 3, where I was critical in terms of my intellectual, my institutional knowledge of the system and the process. So the commission sought my expertise after I was elected in 2011 to assist with the project, to ensure that the intellectual institutional knowledge that I gained from the project, as we could appreciate, in a small society like BVI, there are limited persons with certain skill sets to do certain projects. And I was sought back by the commission to assist with the transition of this process. Additionally, we were able to get that project moving. And subsequently, with a team, of course, I was a member of a team of persons who got that project done, but I was a lead at the time on the project. And I am happy to have been a part of that process, because that system, after the hurricanes of 2017, was the actual tool that helped us to really transition in terms of revenues that were collected through financial services. We were able to, after the storms, be up and running 1 week after, because of Virgin's ability to operate remotely. So that was the reason why that was sought. The reality is that I got legal opinion at the time from both the sitting Attorney General and from private lawyer that advised that based on Section 67, where the commission is a statutory organization, I was not required to seek that permission in the House of Assembly. But through making sure that I was transparent in the process and making sure that I made it clear that what my intention was, I went through the process in the House of Assembly.
And was it down to you to bring the motion before the House of Assembly, or was it brought on your behalf?
It was brought on my behalf.
Now you said that was in 2012.
Yes.
And that was the only time when you were a subject of the motion.
It's the only time.
Since then, to your recollection, how often have there been let's take the 2011 to 2015 House? How many such motions were there placed before the House?
Not many.
Can you try and give a number to not many?
I think less than 5.
And in this House, 2019 on, 2015 to 2019, was that a similar situation? A small number of motions being put before the...
2019 to now?
2015 to 2019 first of all.
I can't recall any between that period.
And between now, 2019 to now, have there been any such motions?
There have been motions.
How many have there been?
3 of them that I'm aware of, that I could remember right now.
Now, as a member of the House of Assembly, you obviously get to debate and vote on the motion. What information, and you're sitting in opposition, what information is provided to you as a member of the opposition, so that to allow you to assess the motion, the merits of it?
We would get the details of the resolution or the motion, outlining the specifics of what the member is seeking, or what the member is seeking to do, or whether it's through a business or through personal relationships. And I think whatever additional documentation is necessary to complete the process can be sought in order to get that process completed.
What stages, and this is as a member of the opposition, at what stages in the process can you seek further information?
You could seek before the motion comes to the House, because the motion most times it's to give notice, and you will have it when the other paper goes out. You could ask for additional information. You could ask for additional information on the floor. You could ask for a recess of the House to get additional information. You could ask for additional information at several different points of the process.
If we take the example of asking for more information or asking for a recess, is that the sort of thing that has to be voted on?
Typically, the speaker allows, if a member has a concern, a point of privilege, or a point of information, would allow it.
Thank you. The last topic I hope that well, I'd like to cover with you.
Yeah.
And it arises out of other evidence that has been given to the Commissioner, but I think you provided today a report which has come from the Office of the Deputy Governor concerning, and it's the report from the Ad Hoc Elections Legislation Committee of October 2020. Do you have a copy of that with you, Mr. Penn?
Right. I'm not seeing it, yes.
Thank you. And just so that we can, for the transcript, give it context, if we go to the first page at 1, I'm just going to summarize. What it says is that Cabinet in its meeting of 5th of February 2020 agreed that an ad hoc elections legislation committee be appointed by the Governor. And the Deputy Governor was appointed to serve as chair of the committee, and there were a number of people appointed to it, including yourself, and you're there listed as representative from the House of Assembly.
Yes.
Now, we won't need to go through the entirety of the report. I just want to pick up a couple of points and then ask you what the current position is. If you go to page 6, and there is, and this is the section of the report dealing with the Supervisor of Elections recommendations from the 2019 general elections. And it's part of a table. Item 8 is the recommendation is electoral campaign financing, rules to be drafted to regulate campaign financing. And it's ticked as or crossed as a recommendation that the committee accepted. And then the comment is as follows: the committee agrees with this recommendation as it creates a fair and transparent process and eliminates acts of corruption. However, research will be undertaken to determine how this will work in the territory. The following comments were made. Options for financing should be included in the rules to support those who do not have as much money to finance their campaign, but still have an opportunity to fully participate. And secondly, some controls may be necessary. I pause there. Can you assist the Commissioner with this? In terms of the reference to some controls may be necessary, what sort of controls did the committee have in mind?
I don't think we were specific about those controls. I think this was supposed to be a further discussion in terms of the way forward for campaign financing.
I see. So this report is December 2020. Has there been further discussion within the committee about taking matters forward?
The committee had finished its work with the report and it was submitted. And there was a discussion, I believe, with the House of Assembly on the report.
On the content of the report.
Yes.
And looking at this specifically, because the committee considered a number of recommendations, but we're focusing on electoral campaign financing. After that meeting or debate in the House of Assembly, what other steps have happened since in relation to electoral campaign financing?
None that I'm aware of.
If you go, please, to page 14. This is the committee's consideration of observer missions recommendations from the 2019 elections. And recommendation 10 was to increase trust in the system, comply with the UNCAC, that's I think a UN convention, and remove the risk of corrupt practices. The Virgin Islands authorities must legislate and institute policies for candidate and party financing and the registration of political parties for financial reporting purposes. And the committee that you were a part of agreed that recommendation and made the following comments. The committee agrees with this recommendation as it creates a fair and transparent process and eliminates acts of corruption. However, research will have to be undertaken to determine how this will work in the territory. The following comments were made. Options for financing should be included in the rules to support those who do not have much money to finance their campaign, but still have an opportunity to fully participate. Some controls may be necessary. Now that's obviously, those comments echo what we looked at a few moments ago. But again, this, as part of the report, was taken to the House of Assembly, was it?
Yes, it was.
And subsequent to that, are you aware of any further steps being taken on this point?
I'm not aware of any further steps.
What it includes is that the reference to some research will have to be undertaken to determine how this will work in the territory. As far as you're aware, has any research been undertaken?
The committee finalized the process. I am not aware of anything that's happening beyond that.
I see. If you look at 12 on the same page, the recommendation that was made was it is recommended that price lists for campaign ads be published prior to the start of the campaign so that all candidates enjoy equal opportunities and that compliance with campaign finance rules to be developed can be adequately overseen. Now, that was a recommendation with which the committee that you were part of disagreed. And what the comment is the committee did not agree with the recommendation. They agreed that a policy on campaign pricing can be proposed where prices are made public, but the Office of the Supervisor of Elections has no authority to regulate. Now, I don't know whether, if you can elaborate on that. Why was this a recommendation that the committee did not feel able to accept?
I can't recall this specific discussion, to be quite.
In relation to the issue, the publishing of price lists for campaign ads, where did you fall in relation to that issue? Were you for the recommendation or against it?
I don't foresee that being an issue, the price list or the price list across the board. So I don't see it being an issue not publishing this.
So on a personal level, it's not a particular difficulty for you.
No.
Just on the, if you can help me on this, this was an ad hoc committee.
There was an ad hoc committee, yes.
And in the background, at the beginning of the report, it says that Cabinet agreed that this ad hoc committee be appointed by the governor.
Yes.
So the committee was appointed by the governor. So did you formally report to the governor? I mean, I know this went, you say, to the House of Assembly as well, but it was a formal report to the governor and then it went to the Cabinet and the House of Assembly too.
I don't know if the chairman did. I don't know if the chairman did.
Right. Because
this particular discussion, I really can't recall it. So I don't know if the chairman reported.
So you're obviously involved in preparing the report, but what happened to it after it had been?
The deputy governor was the one that was supposed to finalize the report. Who was the chair?
Right, because he was the chair.
Yeah.
Yes, no, I understand that. That's helpful. Thank you.
Mr. Commissioner, I've come to the end of my questions. So can I conclude, first of all, by thanking Mr. Penn for coming this afternoon to give his evidence, but also for thanking him for the way in which he has given that evidence to the Commission.
Yes, thank you, Mr. Penn, for your time and coming to give evidence. It's much appreciated.
All right, thank you.
That concludes our business for today, Mr. Commissioner. We will have witnesses tomorrow. I think we will start at midday tomorrow with those witnesses.
Yes, good. Good. Thank you very much.